In leave of my Lord Mr. Justice Parthu Pratim Roy, my Lord, I am mentioning a matter before my Lords. My Lord, this is in connection with a review application. A judgment was passed by my Lords before the circuit bench at Port Blair. This was passed on 7th of January 2025 by my Lord sitting with Justice Supratim Bhattacharya. Therefore, my Lord, I was only humbly submitting that as and when the business of the court will permit and subject to convenience of the other honorable judge, you know, if the review application is taken up, because I had a talk with the lawyers, they said that they are ready to do it in the virtual.
So this was not decided,
The review application which was filed was not decided
and I passed the main order while I was there
in the circuit bench at Port Blair.
Let me find out who his lordship.
Just
Give the details.
yes, I gave the order along with the mentioning slip.
Normal procedure. These circuit bench matters can be heard.
Your circuit bench matters can be taken up provided the particular lawyers who had attended the proceeding, they do not have any objection to that.
So how do we gather that?
That can be done by the Registrar General of our court.
No, but when you are mentioning with
I had
that they are going.
because Milord, what happened is that the learned lawyer Milord, who was appearing on behalf of the petitioner, he had instructed me.
No,
I told him Milord to take the information from the other Milord lawyers.
So, if we may suggest one thing, I may suggest one thing.
Yes.
I have a bench which is lordship on second. So, in the meantime, you ask whoever is instructing you,
Yes,
that he should take the consent of all the parties who are to appear.
I can take the consent from the other parties, and I can the first sitting of the court on day after tomorrow.
You may give it if they may they may convey a written consent. We'll place it on record, and then on second it can be listed.
Grateful tomorrow.
Means this is the appeal matter, recruitment rules violation since
What do you want?
1981.
You want inclusion?
List.
Give.
Permission to mention, Lordship, for inclusion in the list.
Please give.
Grateful, Lordship.
Item number 1.
Matters that I appear with Mr. Vajpayee.
You are appearing.
Not I appear with Mr. Vajpayee.
Oh.
I am for the state.
So which side? You are this side or that side?
This
side. You are confusing us.
No,
Early in the morning.
I am on the right.
All right. So who is for the appellant then? Advocate petitioner. It's a fresh case.
But this is but this was pending before the learned tribunal.
Before us it is a fresh matter.
Yes.
So,
It says 2017 to be post challenged in the year 2018 before the learned tribunal. No interim order was passed. So, Lord, we shall file, my Lord, an affidavit to this subject to my Lord's kind sign.
no, let them be here, then we'll see.
Yes, as my Lord.
None appears for the
Thank you.
Item number 2.
1, 2, and 3 identical matter.
All same. Same recruitment process. All from the same recruitment process. Same order in all 3 cases. Very well. Same order. Next.
Now four.
I'm for the appeal. What happened, madam? The regular bench is sitting, decided over by my Honorable Justice Raj Shekhar Month. Raj Shekhar Month. As for the single bench order, we impinged order passed by Raj Kumar Month. So I make it assigned for the Lords by to Secretary of the Chief Justice.
It has been assigned.
Yes.
Yes.
Matter almost heard by his Lordship, Honorable Justice Tapapato Chakrabarti, as his Lordship there on now he is acting Chief Justice with Rai Chakrabarti, my Honorable Justice Rai
It
Chakrabarti.
arises out of an order dated.
My Lord, impinged order.
Yes.
Yes. Impinged order dated. Impinged order dated, my Lord, 22nd March 2024.
Is it in the paper book?
Yes, my Lord.
Which page?
Yes. Nine.
Yes.
The handicapped certificate has been cancelled.
Where is your disability certificate? Which page?
Which page?
The disability certificate. Where is it?
Yes, yes. Page, my Lord. Page 46. 40%. In 1996.
And where is the assessment by SSKM?
That I have not, no, I have not given any copy of that.
Not given a copy.
No,
Where have you stated in the appeal that copy was not given to you?
no, I have not stated. Sorry.
Sir, please read paragraph 3 of the impugned order. You make a submission on fact. Please be very sure of what you are submitting.
Entitled to copy, no copy has been given.
How can we take it from a lawyer when the client does not say? A statement of fact is not made by the client and you will say so.
No, they have not.
Sir, again read paragraph 3 of the Leonard Single.
I've gone through that.
So if that is wrong, did you file a review that how you are saying this when you have not given a copy to me?
No copy has been given till now. I am
Sir,
saying.
please try it. You may say it 10 times. That will not improve your situation. You may say it 10 times if you want. You are only going in circles. What we are saying is the order records that you may challenge it. If you don't have a copy, what is the remedy?
So far, I can remember me not. What?
If you are not given a copy, what is the remedy? First, you will say that you are not given a copy, which you have not said. Secondly, if that is a situation, you have to go before the same judge saying that how you have passed this order, it's an error of record since no copy was given to me. How you can come in appeal and say that it was not given?
It was argued.
Now give us the answer on this. What is the legal position?
Yes, madam.
How we can entertain such a plea? No statement, no remedy availed in the process. You will say anything in appeal. You cannot.
Really? From the order itself, clear that assessment of the SSK hospital is 19 only.
What you have moved the writ court for? What was your prayer before the writ court? Take us to the prayer. Which page? Show us the prayer.
Yes. 22 million. Prayer.
I've seen it.
Prayer 42. Page 42.
What is wrong with the order? He has asked you to challenge it. You may challenge it. Who is stopping you?
It was argued before their lordship, Honorable Sabam Chokko, Chairman Rai Chottawal. My lords are satisfied. Thereafter, ask them to produce the paper regarding the genuineness of the certificate of the handicap.
What
Yeah.
is the point in making such submission? What you argued there, how it is relevant before us?
What
Is it relevant today? It's not relevant.
Yes.
What is your case? Tell us, what is wrong with this order? There are two certificates. Which one should prevail?
Earlier will be prepared.
So earlier it has certified you to be 40% disabled.
Yes, Mr.
Show it. Where does it say 40% disability?
46. Page 46. Can you look at page 46?
Yes. It's percentage of disturbance, 40% part of some. It's not 40. Okay. It's below the signature. How it can be below? This cannot be, sir. This 40%. What does it say? I don't know. What is there in the bracket? There is something in the bracket. This is not the way. See here also. 40%. No, that is not. This is certificate issued under the Right to Disabilities Act. That you know. Yes, it is not on that. It is not. And what is the date of this certificate? 96. 96. On the signature of superintendent is 96. First Mr. 16 years. I found find that he is accordingly. What does it say? I don't know. Something deformity. Cons deformity. What is cons deformity?
A lapse of more than 30 years.
We don't know. We are unable to decipher your so-called certificate. We are unable to decipher your so-called certificate at page 46. What does it say?
The old procedure, this type of the old procedure, 1996 procedure.
That we understand it is prior to 2016 Act.
Yeah.
It is under the 95 Act.
Yeah.
Under the 95 Act, a regulation was to be made by the state government prescribing the pro forma and procedure. This is not on any pro forma. We don't know what is the procedure. It is even what is been prescribed, we cannot understand. It says for following reasons, CONS deformity. And then 40, and then in bracket, what is written, nobody can read.
This is given by the authority.
Huh?
This is given by the authority. What can I do? I made an application.
What you can do is, you can tell us what it means. You have taken the certificate. So you must be knowing what it means. You can't say, what can I do? You are the person who has been assessed and given this certificate.
I know 1996 made an
So
application.
you have forgotten everything from 96. Sir, you are the petitioner. We are not asking you as a counsel. Where is he said what is the nature of deformity? Where is it? In the OS, show us, in the writ petition. What is the nature of deformity? Show us.
This several times renewed by the authority again and again. What can I do? This is a fault on the part of the authority.
What is the fault?
This is the procedure.
What is the fault?
46%.
Huh?
46% they have written. I have not written.
What is the fault? What you are saying is the fault on their part?
Your Lordship says me that what is the procedure? What is
No, we are asking you what is the handicap, nature of handicap and percentage of handicap. According to you, you are claiming some handicap.
my lord.
What is the nature and percentage of handicap that you are claiming? Where you have said so in the writ petition?
Right. Oh, when the writ petition are filed, the question does not arise. When the writ petition are filed, the question does not arise. No, accepted. Each and every body authority has been accepted. Accepted. I have been asked for interview. Everything has been done. That time, the question it was not challenged by the authority. The handicap certificate. No court has said the handicap certificate is wrong, etc. At the time of hearing, last date, the Honorable Justice my lord, the Honorable Vijay Gangavada said the certificate is not explained, explained properly. But after 30 years, 40 years.
This is the first one. Plan is of 2011. The panel P3. Yes. P3. Why? Hmm. Pain challenge the entire recruitment process before a order is at page 120. Here it is, 136. That is the inquiry. It is after the court's order. There is no entity of the name of fiction. Yes, page 1. Sorry. Why you have not annexed the complete reasoned order?
Yes, sir. Oh, sorry. Reasoned order is made out at by that cover. I'll submit it.
Come to 148.
Yes, sir.
Where is the second page?
Wrongly does not give any here. Sir, wrongly it is not given here, my lord. For that purpose, my lord. Your Honor, my last occasion, my lord directed me to put the original order. I put the order.
Where is it? Give us. Where is it?
The reasoned order, second part is not there. I have seen it.
Where is it, sir? We are asking you.
I tell you, right. I'm giving you 1 minute.
You have challenged this order.
Yes, I have challenged.
Where is the prayer seeking quashing of the reasoned order? The date also we don't know.
Mark about.
Yes, where is the prayer for
Right.
quashing this order?
It is the complete order.
Please show us the prayer where you have challenged this reasoned order.
No.
Where is the prayer challenging this reasoned order?
No, there's no such prayer for quashing.
Then how the direction can be given to appoint you, which you have sought in the writ petition?
I paid for appointment. And
That's why we are asking you
yes, my lord.
how it can be granted without challenging the reasoned order.
I think today I'm not today not so prepared because
No, you are fully prepared.
no,
You cannot change these facts. That's the whole problem. You are fully prepared. How you can change this fact? How you can change the prayer of the writ petition? You cannot. It's not a question of being prepared or not prepared.
then I think
So therefore, tell us in absence of prayer challenging the reasoned order, how a direction can be issued to appoint you. Is it possible? Without challenging this order, no relief can be granted. Writ petition should have been dismissed on this ground itself. Forget about your certificate and other things.
my lord, your lordship can mold the pair also.
Yes, we should do everything. Why not? That is the law.
Keep it for tomorrow. Keep it for tomorrow.
Enough, sir. Enough.
I'll satisfy.
We have given you enough time, half an hour.
Today I'm not ready because
Where is the question of ready? There is only this point. Nothing else is required. We understand 96 certificate given. You say there is nothing that can change that certificate after 30 years. That point you have argued very well. Now the second point we have raised, that in absence of challenge to the reasoned order passed in compliance of your earlier writ petition, any relief whether it can be granted to you. Where is the question of preparation?
my lord, the ends of justice or lordship can do that.
Very well, that we can do.
Your ends of justice, lordships can do that.
That's all. Take down. Third learned advocate for the
irregularity as well as illegality with some malafide and arbitrary intention as well as action on the part of the respondent authorities have failed to communicate the appropriate order of appointment to the petitioner till now. It is sure of the selection procedure as well as the above said malpractice and preparation of the panel. Appointment thereon on the other way and was not done. Your petitioner must be selected and entitled to it. But the question gross irregularity is there. Gross irregularity is there.
It is pointed out, my lord, in my
In my petition, I have pointed out, my lord, order passed by the, Director of Education, paragraph 5. Kindly look at paragraph 5.
Yes,
I have taken that point in my petition also.
yes.
But pair is not there to quash. That does not mean that I cannot get appointment for that. I cannot get the chance from your lordship. Irregularity is accepted by this authority.
Yes.
I have challenged the selection procedure itself.
That's all. Take down. Heard learned advocate for the
Number 5.
This problem which I find here. Whole thing will get. Yeah.
My lord,
You have filed a.
Yes, I have prepared some option.
Give him a copy.
uh, my lord, I also submitted the UGC Act and also NAC.
If you want to reply to that, file your reply, then we will consider. Keep the UGC Act right now. Keep it right now.
Accreditation.
Keep it right now. Whatever they have filed, if you want to reply to that, then you reply, then we will consider. Otherwise, without giving you opportunity, we will not proceed. The opposition affidavit in opposition, what is it, report?
Note, my lord, notes of submission. It was in compliance of your lordship direction, my lord, we have filed notes of submission.
It's an assigned matter.
Yes, my lord, yes, assignment. My lord, matter was before the honorable just, my lord, courtroom number 1, but in previously in petitioner's matter.
Ninth, we have that. Ninth, we have that.
My lord,
It will come before the same bench on 9th.
My lord,
It will come before the same bench on 9th.
9,
That bench will resume on 9th.
my lord.
my lord, actually,
Let
my
the-
opposite parties advocate.
You are asking us.
No, I don't,
You are asking us.
because it is totally.
You are asking us.
Yeah,
You are a very well-educated person, sir. You are a highly educated person. Don't do this. He has given you a copy. If you want to say that he is wrong, he is misleading, you can say it by 9th. 9th, we are going to take it up.
it's just.
আমি রিসিভ কি করবো আমি দিয়ে দিলাম তো
না,
আমি ওপেন করে
Number 6.
I appear in this matter for the appellant, Indian Statistics Institute and others. This is pertaining to payment of gratuity. Payment of gratuity at what rate? Now, there was a memorandum issued by the authority of the ISI, Indian Statistical Institute. Now, subsequent in 1963, thereafter in 1972, the Payment of Gratuity Act came into force. Now, the question arose at what rate the payment would be made in respect of gratuity to the employees. Now, we followed the Payment of Gratuity Act in respect of payment to the writ petitioner. Now, being aggrieved by such payment, he moved the writ petition. Now, yes. Now, the ceiling limit.
How the 1972 Act applies to you?
Because the payment of gratuity in accordance with the Payment of Gratuity Act,
Is it always?
No, not always.
Therefore, we are asking you how it applies to you.
Because my lord, we adopted.
Where is that? Show us that order by that circular decision of board, whatever, state government's notification that the employees of this institute will be governed by the payment of gratuity.
But I will come to that. But before that, if
But
you
that is the primary thing, sir.
before that,
Either they are covered by 72 or they are not covered. That is the only thing.
that is the
So
only-
show us how they are covered by.
if your lordship kindly sees the impugned judgment appearing at page 69.
It may be wrong,
No,
but
no,
if
for
it
the-
is
for
wrong,
the-
we have to see that you are covered by
But
1970.
for just recapitulation, if your lordship kindly sees not page 69 onwards,
Yes.
I will just trouble your lordship with certain paragraphs of the
Yes.
judge. It ends at page 114.
Yes.
Now, my lord, if your lordship sees how the learned judge, my lord, dealt with the issues. But paragraph 52, if your lordship sees at page 113,
We have read it. Where is this memorandum of 30th November 2015 and 7 December 2015?
Yes,
Where
yes.
are these two memorandums?
just a minute. Wait, sir.
Page 48, 49 of the paper book.
48. Thirtieth November 2015, yes. না আর একটা মেমো কোনটা? এটা তো মেমো অফ স্যাংশন। আর একটা পেজ কত বললি?
That 48 আর 49.
49.
হ্যাঁ,
হুম।
49.
You are,
This is
the institute is identified with the state government or central government?
central government.
So Union of India is a party.
Yes.
Who is appearing for the Union of India?
No, no, Union of India. Union of India 42, দেখতো? 40. But respondent number 4 is the Union of India, but nobody is appearing.
In the writ court, they were represented or they were not represented?
But in fact, as I am told, we have been assigned for all the respondents in the writ petition, that is appellants.
You have been assigned
Yes,
for union and
Yes, yes.
institute both.
yes. Right.
Saying that the
Is any final decision taken by the CAG?
that I am aware of. My lord,
Merely there was an audit query on the basis of which this amount of gratuity has been
That is
raised.
why we are asking, did the CAG finally take a decision? That is the only thing.
That my learned
They are not disputing that they are entitled to more than 10 lakhs. They have said that yes, they are entitled to more than 10 lakhs.
my lord, the institute has in fact, my lord, all along my lord, supported this, their own stand.
That is precisely what we are saying.
Employees are, my lord, entitled to better terms of gratuity.
Correct. Page 49, they have written to the
But subsequently, my lord, your lordship, this is not annexed to the paper book, but
sir, before that, there is an institute considering the provisions of the Payment of Gratuity Act, which permits payment above the limit. You have been giving this payment above limit to everyone. When it comes to giving it to him, you say yes, he is also entitled. But since CAG has raised an objection, we have given our reply. Let it be decided, then we will give you whatever is remaining. You don't dispute his entitlement. You have not paid because this is coming in the way of discharge of this liability. Now, how you can represent the institute and the CAG both, or the Union of India? Now you tell us. Please try to understand what we are. Yes.
But since the institute is fully funded by the central government, therefore, my lord,
Again, we are asking you. Since the central government is saying you are doing a wrong and you are saying we are doing the right thing, can you represent both parties?
but my lord, subsequently council has taken the decision in terms of the my lord, guidelines of the central government. That is not annexed in the paper book.
But that is not the subject matter. The subject matter is arising out of communication where you are contesting the central government's objection.
Because at that point of time,
So therefore you will represent both. We think it is not proper.
but in that case, my lord, subject
In
to
fact,
what
highly
your lordship
improper.
decides, my lord, we can just request the my lord, Ministry of Law and Justice to my lord, engage a separate lawyer.
Could be, sir.
Yes,
Please try to understand what we are saying.
I understand. My lord.
Yes, read page 49 of the brief. You are saying that their objection is wrong. You have sent a clarification.
No, because my lord, initially, my lord, after my lord, CAG's objection, we took a decision that our
You did not.
decision was wrong.
You did not. This is after CAG's objection, page 49.
Yes, page 49
This
is
is after CAG's objection. This is not prior to.
no, no, 85, huh?
Please,
Yes, but this is after yes.
please ensure some representation on behalf of the Union of India and Accountant General
But
Office.
if you lordship kindly have a look to this, Lord, because Lord,
We don't think it is proper. We are being very clear. We don't think it is proper.
because Lord, decision has been taken
We don't know.
by way of resolution by the council, Lord.
Maybe. This letter does not get obliterated. This letter will still stare in your face.
Lord, in that
Yes, yes, that's why I'm saying. That's why we are saying. Have you given that decision to him?
and Lord, another
What is the date of that decision?
2017 decision, January 27, 2017.
no. এইটা কবে ডিসিশনটা কবে ডেট নেই
From the communication.
Institute Act 1959, that we were bound to take that decision. Kindly have a look.
We'll
at
see
this.
after they are
Yes,
represented.
yes. Great.
Item number 7.
Great.
Item 7. And I am appearing on behalf of the CISF. This is the case where CISF awarded compulsory retirement to the writ petitioner.
Compassionate appointment.
Compulsory retirement. My lord, kindly produce the order dated 17th August, my lord.
Under 48 of CCS.
It was hard at length, my lord. And on 17th August, your lordship was pleased to direct
This is also listed on 9th.
highly obliged, my lord.
The matter stand.
My lord, my lord. Item number 8.
Waiting for the response. My lord, I appeal for the appellant petitioner. My lord, before my lords, my lord, take up the file and begin. May I just candidly, my lord, confess, my lord, on the last day, my lord, I said that my AOL, my lord, has met an accident. He is, my lord, still not
Accident. Oh.
accident. He is still not recovered. So, my lord, I could start, but I could not conclude today. There are certain documents and judgments, my lord, I would like to refer. My lord, it's my duty to point out at the very beginning.
So for my submission is, my lord, the scope is very limited. He has been given opportunity in all, he explored all the opportunity. And after that, he was removed from service. The serious charges are against him. He tried to attempt commit suicide. Deepajyoti Boshu. কথা বলতে পারবো না, বরুণ চ্যাটার্জি দিয়ে দেবো।
He has not crossed his superannuation age.
My lord, no. He, my lord, I have taken instruction. He is around, my lord, 40 to 43 years of age as on date.
You don't want to do it today.
Well, I have expressed my difficulty. I could, my lord, proceed, but could not conclude. There are certain papers and documents and judgments, my lord, in view of his absence.
No, we understand, we appreciate that your
My lord,
visiting council has met with an accident.
my lord.
At the same time, you are saying you can proceed. At the same time, you are saying you will not conclude. So therefore, we are unable to appreciate the submission. The documents are here, the file is here, you are here. If you are ready, you may proceed. If you don't want, tell us you don't want. Because we will not hear it partially and
Yes,
then
yes.
adjourn it.
then my lord, because there are certain judgments, my lord, I would like to refer. My lord, my principal point of argument, my lord, that I would be trying to develop on the adjourned date. My lord, there are on the self-same ground, self-same charge, my lord, there is also a criminal case where, my lord, the final report was filed. So, my lord, even prior to, my lord, being tried, my lord, I was discharged. So, my lord, the degree, my lord, that, my lord, the Honorable Supreme Court and my lords have time to time have considered, my lord, it goes even higher to that. My lord, it's not even, my lord, a simplicity or acquittal. It's something, my lord, the police, my lord, did not find anything on the, my lord, FIR and the written complaint on the self-same charge, my lord, which on basis of which departmental proceeding had initiated. My lord, kindly, my lord, keep it on any day convenient to your lordship, my lord. I will try to satisfy.
Adjourn time and again, my lord, let the matter be appear after vacation.
Hmm?
Let the matter appear after vacation in that case, my lord. But after vacation, my lord, time and again the matter has been adjourned, my lord.
After vacation.
Kindly sees how many adjournment was taken.
So therefore it should be adjourned after vacation.
Issue is that kindly see that since when the matter is pending, matter firstly the petition was there, that was dismissed for default for non-prosecution, then appeal was preferred. After that this came back, and after that again and again time is being short for, my lord. It's the situation, my lord.
So any interim order has been passed. There is any contempt against you. Then what is your problem? For what these submissions are being made, we don't know. How many times you will take an adjournment? Perhaps the third time you're taking an adjournment before this.
My lord, this is a submission which is made, my
You
lord.
are here with all the documents. The point you are arguing, there are few judgments in support of that. Still, you don't want to argue.
My lord, what he has said is not correct. Of course, my lordship.
No, we have not. Are we saying what he has said?
Yes.
Why you're saying that?
No. Yes.
There are only 2 points. One is whether it was accidental or not.
My lord.
The other is whether the criminal case decision will govern this or not.
Self-same charge.
Regarding the second point you have asked, it is to be governed by the law laid down by the apex court. 3 or 4 judgments are relevant, well known to all of us. No new judgment is required. So why you are seeking an adjournment? We don't know. That accidental issue you have not argued. You are only saying that it is covered by because
No, I said
criminal
my principal point that the accidental part, my lord, that I would also join, my lord, the second as a as my
when sir,
second.
since 2018 this appeal is
My
pending.
lord, I usually do not take any time, my lord, but since my error is not there, my lord, it is only my compulsion. আর একটা বড় অ্যাক্সিডেন্ট করে পুরো স্টিচ ফিচ হয়ে বড়খানা স্টিচ হয়েছে।
This is the 5th adjournment in a row.
Yes.
Yes, doesn't make it any better.
Sometimes he is not there. Sometimes we also took adjournment.
Any order on his ground? Adjournment in this proceeding.
Yes. On facts, not once, but more than once. But facts remain, my lord. He was also otherwise engaged.
You must come up to the same measure. If he has taken 5 adjournments, you should take at least 6.
I should not.
And this is the law which governs the.
No, but I should not. Please, my lord.
Why you make such submissions, we don't know.
I should not.
The learned advocate, senior advocate appearing.
Deeply obliged.
Number 9.
But I'm for the the minor, my lord, respondent 8.
But I'm able to small 4 and 5.
Again,
Who is for the petitioner?
Last two occasion also, on one mallet they have not appeared, on another mallet a passover was,
The last occasion,
they have taken accommodation as prayed for by them.
Last occasion, the learned AGP was not available.
No, mallet, that has not been recorded, but they was taken on the
Then
last.
we will go by the record.
Right,
We
I
will not go by what you are saying.
understand. I understand. I understand.
The record will prevail over your submission.
I
And prior to that, respondent 4 and 5 took adjournment. Yes, how you have decided? Under which provision you are a competent forum to decide that the payment should not be made to a person who is alleged to be an illegitimate child?
Lord, that is the, kindly take up my affidavit in opposition, my lord. I have quoted the law, my lord. In the GPF rules, there is
GPF rules.
GPF, my lord. But I have quoted in it.
Respond number 8. You are respond number 8.
Yes,
4 and 5.
4 and 5.
No, our role is very limited, my lord.
No, you have created the entire problem. Don't say your role is limited.
There is two things which is involved here, my lord. One is the family pension. The learned tribunal has directed that it can be shared by the first wife and the children of the void marriage. This is number one issue. On the second issue, my lord, on the very first date, the coordinate bench of the earlier bench, my lord, that has seeking for a clarification that how much money or what is the exact amount that the petitioner has received. Then, my lord, it is came to know that 22 lakhs of rupees already has been paid to the wife or the first wife. Because I am a illegitimate, they have stated in their notice that I am illegitimate child for that reason. This is one, my lord. And number two, my lord, this is in case of GPF and leave encashment in terms of. And another is, my lord, the gratuity that is pending. And my lord, in that order, for that, my lord, I have also preferred a CAN application. My lord, in that order also.
Where is the rule? Which rule you are
My lord,
relying?
it is not annexed in the, my lord, GPF rules, my lord, 2C1, there is a note. Children means legitimate children. That's why we sought for clarification, my lord.
From?
The department employer, my lord. In the last annexer, my lord, that apart, my lord, the last annexer of my affidavit in opposition. Page 9 of my affidavit in opposition. Regarding division of the family pension, my lord. This is clear.
Page 9.
Page 9 of my annexer 3 of
If rule, what is it? DCR, yes. The question is.
the third paragraph, my lord, referring to. My lord.
কোনটা third? No, my lord, this is a subsequent notification by which they have.
It's a notification of 1997, man.
This is on the family pension, not GPF. This is on family pension. This is on family pension, not GPF.
So how this comes in the way of giving the benefit to them?
My lord, unless this is settled, my lord, we sought for clarification in the next page, my lord. We sought for clarification from the department, my lord.
No. Where is the any clarification is required after page 9?
But yes, my lord, since the first wife and the minor child from the second wife cannot get pension at the same time, my lord. That is the rule of stand of this employer, my lord. The finance department memo. But we are bound to follow that, my lord. That's why we have sought for the clarification, my lord.
Just now you were making submission regarding PF. Now you are jumping to family pension.
No, GPF, my lord, I've already said. So
Yes.
since there is a clarification. The children means the legitimate children, my lord. My lord, there is a status report, my lord.
Come to your page 9 of your affidavit.
This is only for family pension, division of family pension.
Where does it say only for family pension?
Follow 9 to 12.
Yes, where does it say only for family?
My lord, rule 105, my lord. In the first line, admission individual provision continue rule 105, my lord.
Again, we are asking you, you sought for a clarification. There is a memorandum at page 9.
Yes.
You have annexed it.
Yes.
How it comes in the way of grant of benefit to the children?
My lord, since the third paragraph, my lord, is very clear.
Yes,
right
how clear it is? Please read.
The rights of the right of such children required to be protected and will act accordingly.
Yes, such children means rights of such children. Which children?
Children from the second.
Yes.
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 Provided that the pensionary benefits will be granted to the children of a deceased government employee or pensioner from such type of void marriages when their turn comes in accordance with the rule 105.
Yes.
Rule 105 says, my lord, after
Complete.
it may be noted that there will be no claim noted that they will have no claim whatsoever to receive family pension as long as the legally wedded wife is the recipient of the same. The first wife has already claimed for the family pension, my lord. So long the first wife is alive, my lord.
So how the right will be protected in terms of paragraph 3 according to you? See, you are not a party to the dispute.
No.
So according to you, how this memorandum will be given effect and how their rights will be protected?
The rights of the children will be protected only after the first wife, the claim of the first wife goes, my lord. If the first wife remarries or dies, my lord, then the turn of the
where you are getting this, we are asking.
Last line, my lord, if I am not wrong, my lord.
Yes.
It may be noted that they will have no claim whatsoever to receive family pension as long as the legally wedded wife is the
You are confining to family pension.
Yes.
We are asking about GPF and these other dues.
But GPF, my lord, the GPF rule, my lord, to see one, there is a note. Children means legitimate children. That's why we said this.
Sorry. As regards death threat. What share of it?
No, I can produce the GPF rule on the next.
See what they have said.
That's true.
আপনাদেরকে দিয়েছি, এটা আমার রিপ্লাই। আপনাদেরই চিঠি, আমাদের ডিপার্টমেন্টের চিঠি।
Have you taken any decision in terms of their annexure 4? They have no objection. AG has no objection. No, what have you done as per annexure 4? What have you done? In writing, AG says that you make a special provision. I don't know why he is arguing it is not permissible. Yes. Please see annexure R4. They have filed an affidavit in opposition. In their affidavit in opposition, you please see page 3 of that opposition. Please see page 3 below annexure R3. In that paragraph, they have said that there is no provision, but they have asked the state government to take steps. For complying with the tribunal's orders. So it is for you to do. Why you are not doing it?
Made an affidavit.
You see that.
বলা আছে, it can be shared.
Lordship, after our standards, it can be shared. Lordship, let me seek instructions if there is any.
No, in light of annexure R4, what have you done? That is what we want.
That is, I'll have to get.
In light of their statement made in the opposition and R4, what have you done? These children cannot be left without maintenance.
It's not our stand either in the affidavit in opposition.
They are, it is a fortuitous circumstance. They have not committed any wrong.
Lordship, then let me get instructions whether we have issued anything.
And about pension and about the other dues, GPF and dues.
Those what has been paid, how it has been paid. I'll get this.
GPF dues, has it, all of it been disbursed to the
My lord, GPF, my lord, and leave encashment total 22 lakhs that has been paid, already paid to the
That
petitioner.
is the entire amount.
Entire 22 lakhs has been paid, only the gratuity is left out, and that is in terms of an high court's order, that is affidavit is before your lordship by the petitioner. This is number 1, my lord. Number 2, my lord, by the notification.
This amount of 11,49,000, it was paid prior to the tribunal's order or after the tribunal's order?
My lord, during that order, my lord, not after the
How
tribunal.
it can be during, either it is.
No, my lord,
before the-
not after the order, prior to the order. My lord, may kindly take the.
When was it disbursed? You don't know the date.
GPF amount has been disbursed on 11th of September 2020, 12th of October 2023.
And what is the date of the tribunal's order?
12th of June 2024.
Oh.
Four.
At the time of payment of this dues, the OA was already filed or it was not filed?
2023, my lord, it was filed.
After the GPF was paid or prior that? Yes. In May 23, it was filed.
My lord, may kindly take the last, not last, my lord, the order passed by your lordship on 26 November
This is
2024.
the red petitioner. He is not here. What can we do? In fact, in the meantime, you take instructions regarding the family pension.
Page 48 reveals that the way was
May
verified on 11th of
23, May 23.
Yes.
That's what we said, May 23. So after filing of the OA, this amount has been paid. There is none to represent the writ petition.
12 PM matter, item number 116.
Perfect, thank you. Lord, I must introduce myself. My name is Kama, Mr. JP Kama, so that you don't have to say Mr. Counsel. Sorry. Yesterday, my lords had wanted that affidavit. We'll give it to your lordships now.
You are better today. You are all right today.
Yes.
We are asking about you. You are all right.
Oh, I'm all right, yes, I'm fine. This is a passing phase.
Yes, it can happen to anyone. This heat and this traveling and everything.
Variety of factors. I won't go into
Many
those.
factors, yes.
Now, my lords, in this, please turn to page 1061. It's flagged. Yeah. Hmm? Go ahead.
Yes. F and G. F and G.
F and H at page 1064. It is stated, although there were major discrepancies in recruiting the DIH candidates upon third phase of recruitment process, the management purely on humanitarian grounds and on a practical approach does not want to take any steps. Then I must also sorry. Now I must also take you to page 1077. This one. Para 28. It's a little long, I'll just read it slowly. With reference to the contentions and put forward in paragraph 23 and 24 of the applications, it is stated that at the time of scrutinization of the eligibility criteria, the GRSC policy of compassionate employment has come into existence with effect from 27/11/2013. Secondly, the minutes of meeting cannot be considered to be a policy having capability of being enforced in the court of law. And lastly, the averments made in paragraph 18 of the foregoing affidavits leave no room for any doubt that the entire process of recruitment in unskilled category, in spite of the ban being imposed up to third phase, was totally under the scanner of the CBC and MOD. Undisputedly, the respondent company, being under an administrative control, MOD cannot go either beyond the said ministry or the board of directors of the ministry. It is settled law that illegality cannot be perpetuated. So we have taken this point in our affidavit. And this is an affidavit in the matter where the impugned judgment has been passed in the same petition. It's a 2016 petition. So therefore, we have taken this issue. And also,
Intention.
Yeah, 1 second. I'll come to that. What you're showing me is there's a chart contour here.
Yes.
Then, my lords, at page 1078, we have reproduced a chart showing date of expire. Page 1073.
3 or 8?
8, perhaps. Bad print. 8, yes. Now here you'll also will notice that in this affidavit itself, we have pointed out name, date of expiry of the employee, date of application, and thereafter the delay. This has been stipulated by us straight away. Now, if you come to the supplementary affidavit filed by the other side,
So this tabular representation is limited to these fourth phase applicants.
yes, fourth phase. We supplementary.
Which one?
This one, this chart is here. And supplementary.
Yeah, these are supplementary.
Now, Manoj, so when the learned single judge heard the matter, this was the factual position before him. Now, my learned friends have filed a supplementary affidavit in this court, my lords. And I would like you to see the chart reproduced by them at page 23. My lords, it's a chart produced by them in their supplementary affidavit.
This is not part of the paper book.
They're not giving it to you?
This is not part of the paper book.
No. They gave it yesterday, my lords.
Yesterday, we have filed the affidavit in opposition against the stay application.
Supplementary affidavit.
What is it that they are saying? Please proceed.
Lords are seeing a chart produced by them showing that the date of expiry and the date of application are almost a month apart. This is coming into court for the very first time today. There is absolutely no supporting document to this. It's only a chart, never produced at any stage in any proceedings. Whereas we have produced, I'm sorry.
We have prepared one supplementary affidavit, but and served also.
That's why.
No.
We are still, I don't think we have located the opposition that they are reading from.
In this affidavit, I'm sorry, Manoj.
Supplementary. We are sorry, we have not been able to locate that yet.
Did you give it just now? I think you gave it just now.
Just now you are giving.
23. And here they are saying date of death is in the first instance 26/5/1999 and 25/6/1999 according to them is the date of application. Now I must point out, as I said earlier, when we filed our chart before the learned single judge, they have not counted that. Also, they have not produced this there. And this is the first time they produced it in court in the appellate stage. Also, there is not a shred of material on record to indicate that the date of application, the date of application is accurate.
All right. So according to you, it's an afterthought.
Absolute afterthought and a makeup afterthought. They made it up.
All right.
And there's just one last thing, my lords. Your lordships had wanted to know what we did with the charge sheets issued to our officers. This. Oh, what to read this? 756. In my compilation, I want to show your lordships what happened to those charge sheeted officers since the duration. In our volume.
Acha.
Is that? No, not theirs, ours.
Not yes, yours.
1056. The names of the officers concerned are here. Government displeasure, reduction to one stage in the lower time scale, and reduction to one stage in the lower time scale. Now, The
6 months.
6 months, yes. Now, the first officer was given his government disclosure. The second was given disclosure, and then he was he was suspended from service.
The tenure has not been.
Same volume. This is does it say suspended? Does it say suspended? No, wait, how much?
Yes.
Now, Manoj, the learned friend for the other side mentioned yesterday that they were suspended and then promoted. The only one promoted was one, and he was promoted at the fag end of his career. Just 9 days prior to his cessation of employment. So he suffered that for several years until the last year, and then he caught the promotion and he was given it.
Normally, the effect of these minor punishments are lasting for 3 years. So after 3 years, they would have been eligible for
That's right.
promotion.
And
Normally, unless there is a provision
in this
to
case,
the
I'm told it was 4 years.
Oh,
But 4 years.
4 years.
But no, look at the rank. Ex-CMD, ex-director. Now, for these people to be even reduced in rank or suspended is a serious misconduct for them with their rank. And this Mr. Verma, he was allowed to continue, and then he was removed from service. If your lordships turn to page 619 of my to 205 of my convenience compilation. Show me that. Give it to me.
$205 is volume 1.
Yes, no, Verma. I got it.
Yeah.
No, he was occupying a tenure post.
Yes.
And that tenure had ended, so it was not further renewed.
Not further extended. I'm not saying, see the last line kindly, or a third line. Accordingly, the services of Commodore Verma, Director GRSE, may be dispensed with immediate effect. So this was a serious misconduct. And this argument that he got promoted again was only for that one gentleman.
You should be charge sheets.
All right.
Continue. Proposed to hold an inquiry. Yes, India. That's it. That's it.
Page 192. Yes.
Charges. President proposed to.
Now, if your lordship see the actual charge sheet also at page 191 of the compilation, 192, I'm sorry. Do my lords have that? No, this is an issue by the President of India. It's not something taken lightly. Proposes on inquiry against Commodore retired Verma, Garden Research, under Rule 26 of the Garden Reach Shareholders Engineers Limited Conduct Discipline Appeal Rules, as amended from time to time. The substance of the imputations of misconduct or misbehavior, in respect of which inquiry proposed to be held, is set out in the enclosed statement. I won't go into all that. It was the same issue. Indeed, my lord may turn to 194 to the articles of charge. Article of charge 1, Commodore retired Verma, while working as general manager in GRSE, signed minutes of meeting with workmen of the union, committed certain recruitments and formulated a compassion appointment policy on behalf of the company, which was beyond his authority. So we have not taken it lightly. That's what I wanted to say.
What is the order passed in WP 13992 of 99? Is it on record?
That order.
13992 of 99.
No, what is the nature of the document so that we can look at it?
Perhaps there was a claim by this Mr. Verma that he has done it in compliance of the order passed by the High Court in WP 13992 of 99, passed by this High Court.
Yes, that was the first read.
I'll just find it for you. Meanwhile,
Why we are observing you, page 195, Article 5 of the Article of Charge.
Yes, 195. Where is that? This 195. The 195 also.
No, 199, this is the first order.
No, this refers to the earlier writ petition.
Sorry?
This refers to the earlier petition, not
Yes, that we understand. It's of 99, it's much earlier.
That's right.
And these are what
And this was, must I say so, even prior to the 2006 MOM. So whether it would have any relation to the issue at all?
No, because perhaps there may have been a, pre-charge memo, preliminary inquiry or something. Maybe, we don't know, that's not before us, we are on assumption. But from the Article 5, it appears that what they are saying is this action is not in compliance of 13992. So therefore, they must have taken a plea that because there is an order passed in 13992, we have to.
What we'll do, Manoj, we'll research this point and come back to you. But for the time being, what your lordship says seems
No,
to
we'll leave it at that.
very well.
Because we have seen the order, it does not in any way say anything like this. We have seen it says that subject to availability of vacancies, when the ban is lifted, and only after then how it is to be done. So
Also, I must point out that all these recruitments in the case of Compassionate were all casuals. All the selections at that time when the advertisements were issued were all for casuals. I'll show that to my lords. Now, these people were part of the group of casuals who came to the company, and out of them, certain of them were given compassion appointment. This is not possible if compassion appointment is correctly executed.
So prior to their compassionate appointment, they were already working in casual basis.
No, they were taken in on casual basis. But the point therefore is ultimately, can there be a mandamus issue by the learned judge to appoint a casual? That's the next question. Although to be honest with you, he hasn't really directed. He has said, consider their poverty status and then appoint them. But there cannot be an appointment of a
So in effect, enforcing that understanding, which you say is an understanding,
yes.
enforcing the understanding.
That was the understanding. But the point is that ultimately the court cannot pass a mandamus directing reinstatement of casuals. There was no termination of compassionate. They were part of a group and they were not taken. But at all times they remain casuals.
What is the factual position when you say the fourth phase persons were not given the benefit because it would amount to perpetuation of an illegality? Does that mean that despite their not being offered an appointment, they continue in casual basis?
They were not appointed. That's what I'm saying. They were due to be appointed in the fourth phase. They were part of a group of people who had come to the company in 2006. The company made 4 schedules and they were going to appoint them by those 4 schedules. And my respectful submission, that's just not possible in compassion appointment. Compassion appointment has to be a man died today and his child cannot continue tomorrow. He has to give something. This is not the principle of compassion appointment. And in any case, at all times, appointments were on casual basis. All 4 advertisements, I'll show them to my lord in a minute. All 4 advertisements were for casual employments. The earlier 3 thereafter became converted into permanent. But at the time of appointment, they were casuals. So today, the question which would arise for your lordships is also this. Okay, can the court direct appointment of casuals? I can take them today and throw them out tomorrow. What's the point? Also, the law doesn't compel me to take casuals. Today, I need casuals. I take tomorrow. I don't need casuals. I can't be forced to take casuals. Now, for this purpose, my lords need to see the advertisements.
We never took any person in fourth phase. Fourth phase is
Turn my lords kindly to volume 1,
73.
1 second.
Page 52 is one of the advertisements.
73.
If my lords will turn to 52 for a minute. of my compilation. My lords have that? 52. Look at that heading. Invites for application for the post of casual laborers. So this was the first phase. The second phase is at 59. Again, invite for application of the post of casual. Come to that. Only one thing I must point out here, in all fairness. In both these advertisements, there was a preference given to compassionate. But that in itself would be a breach of Article 14. Because that means you are giving undue appointment to somebody at the expense of somebody else. And this somebody to whom you're giving it under the guise of compassionate appointment is not entitled to compassionate appointment on the date of advertisement. Then kindly turn to the third phase, which is at page 66. And this also is casual. And the last one, the fourth phase, is at page 73.
Executed.
And this also is casual.
Where is the third
Page
advertisement?
73. Third one, I'm sorry. Third one is at page 66.
And second one?
Second one, Manoj, is at page 59.
Yes.
Since your lordship is on page 59, let me show you, Manoj, also page 62 for a moment. Clause M. Reference will be given to the eligible candidates of the deceased GREC employees who died in harness, subject to merit being equal vis-a-vis other candidates. Dependents should indicate the name, etc., etc.
That same clause at page 55 also.
All of them.
55
So,
also.
out of the bunch of casuals, a certain preference was be given to one group. Now, I can understand if there is an intelligible differential based on rationality. But here, you're giving this to persons who are not entitled in the title of compassionate employment. And in doing so, you're depriving other people who could have got the same jobs.
R also at page 56.
I'm obliged. Page 56.
R. It must be same in all the three advertisements.
Yes, identical. Employment, no. Age relaxation, in all of them. But this is recruitment. This is regular recruitment. This is not compassionate appointment. So whether or not I protest against it, it still can't be done. As I say in the case of jurisdiction, merely fact I don't raise jurisdiction does not absolve the court of looking into the jurisdictional issue. So therefore, at all stages, there were casuals. If I am to appoint...
You only pointed out because this can be clubbed with M. Whatever your submission is with respect to M, this will be also governed by
issue.
the same submission. Therefore, we pointed out.
And also the qualification. They're supposed to have some qualifications at least.
That is also relaxed by R.
Qualification applicant should have requisite minimum qualification as per the rules. Age is relaxed.
Age and qualifications may be relaxed, both.
But nobody has seen the qualifications here, and the final report which we have filed says they're not qualified. Now, the point is ultimately, these people have been found, none of them have been found to have the requisite qualifications to be appointed. None. So whether or not I have raised an objection, whether or not the CBC or the MOD have stopped us, the point remains that today On the date when the learned single judge passed the order, there is a report saying that none of them are qualified. Now, the division bench gave them an option at the end of this judgment, saying, if you have a grievance against these findings, challenge it. And they have not. Indeed, the learned single judge says, okay, they have not challenged it, but I can issue a mandamus nevertheless. I'll come to that when I read the judgment. So therefore, I was just clarifying.
They did not challenge the rejection.
They did not, and in fact, the learned judge says they have not challenged it, but we can issue a mandamus. That's what the learned judge says. When I come to the judgment, I'll show it. I don't want to go up and down. So therefore, they have not challenged it.
Where is the prayer of the writ petition, prayer portion of the writ petition?
I'll just show you the judgment itself. The impugned
First, we
judgment.
would like to see what they prayed for in the writ proceeding.
It's a rather vague prayer. I'll show it to you. My petition. Where's the petition? 511.
511, volume 3.
Volume, volume, yes. Yes. And the judges said they're not challenged it. Why are you going on there? 1 second. Hi. My lord said that at 511. A writ and or writ in the nature of mandamus commanding the respondents and each of them their servants and agents assigned, etc., to appoint your petitioners as being dependents of the deceased employees of GRSC on compassionate grounds on the post of operative writ and or in the nature of mandamus commanding the respondents and each of them, their men, agents, and subordinates to rescind, recall, revoke, or withdraw the order of the rejection of their petitioners' candidates in the post of operatives. Now, if I were to take you through the petition itself, your lordship will not find a single individual challenge.
Ground they have stated that this finding of the report is wrong. Prayer is an omnibus in nature. Omnibus in nature. Contrary to the dictation. Omnibus in nature. Individually, there is no treaty.
That's right. That's right.
And what is the date of the rejection order?
Of the
By you, when you have rejected their claim?
2009, my lord, when there was
14 January 2015.
After the High Court.
After the High Court, I have not stayed them. We've come to your lordships, that's all. Can I just finish what we were earlier saying, my lords? The lordship will remember that in the division bench order, what is said, accordingly proceedings are dropped. It is seen in, it is open to each individual to assail the decision of the committee if they desire to do so.
Which decision? Assail which decision?
The decision of the committee was a report.
That is what we are asking you.
Report, my lords. The decision of the committee was a report of the committee.
Where is that?
It's in the contempt order. No. 1 second.
That decision, the report.
The actual report, my lord.
Yes. So this was not put to challenge.
No, not put to challenge. And that was what was given liberty for.
Now, this report of the committee,
my lord,
it was part of your affidavit in opposition filed before the contempt proceeding?
Yes, it was shown to the learned judges.
And that has been put it.
And it is in fact reproduced, my lord, in the judgment of the division bench. Now, here, just for a moment at page 305, I want to show your lordships.
What is the date of this? 14 January 2015.
Alas. 3059. 305. My lords have that. At the bottom of the page, para 11,
No, sorry, what are you referring?
305 at the bottom of the page. Yeah, as part of the report itself. No,
It's not in this. Second one.
This 14 is the division bench has quoted from there. Just align.
Yes.
At 305, the committee then decided that a detailed database of the 109 applicants as per available records of HR is to be prepared. In continuation, the committee will seek penury certificates to assess the penury conditions of each applicant, which is to be obtained from the concerned revenue authority or government of West Bengal, which is authorized for the same and in-person visit to the office of the SDO reveal the detailed process. The committee then met on 4th August, 8th August, etc., to study the 9 service files and to finalize draft letter format to inform to applicants to submit penury certificates. Also enclose a sample letter how to apply for the concerned revenue authority for obtaining penury certificates. Please turn to the next page. 15. On scrutiny of the 75 responses received, it is found that 9 candidates submitted the income certificates issued by the concerned revenue authority. Balance 66 respondents only represented enclosing certificate issued by local councillor or MLA. The committee considered the same are not acceptable and accordingly recorded its decision on each of the representations thus made. A sample of such response is placed on an extra. Hence, these 66 cases of representation are not considered for further processing. The committee also checked the DIH register and found 19 names out of 109 names are not appearing in the DIH register. Ultimately, my lords, turn to page 312. Watchers will find that the committee found that not a single one of them was qualified. On also have page 312. At the bottom of the page, paragraph 22. Therefore, when the matter was before the learned single judge, he had a report which said that not a single one of them qualified. And yet the learned judge, despite the report and without challenge to the report, has passed an order for their employment. This is where I take issue with the learned judge.
Para 14. This has been quoted in the division bench. 478.
Para 14. 78.
Yes.
This report from para 14 onwards has been quoted verbatim by the learned division bench at page 478 onwards. So therefore, at the end of the day, no matter what, suppose I didn't object, I did object, whatever it is, if they are not qualified, they're not qualified, and that's the end of the matter. They can't be appointed.
And individually, they have not challenged.
Now, the challenge, as I mentioned earlier, has to be individual. There is an omnibus challenge, you set aside that order. But set aside the order must be individually saying that when the authority said, I don't have the qualification, when the authority said, I don't have the proximity of death to application, when he wanted to say, when the authority says that it's wrong, here is my certificate to show that I was in fact appointed very shortly after the death of my forefather.
His order is referred to.
Right, before that.
Not possible to replace.
Also, Manoj, there's another issue. I know I'm going beyond what I was arguing just now, but the learned single judge in his impugned order says that it is for me to go door to door. I ask myself a question, why me? It is for them to establish that they were suffering penury. Not for me to go door to door. Also, how in the year 2024 or 2025 will anybody prove that in 2006 there was penury? The impugned order therefore becomes beg your pardon?
No.
Therefore, the impugned order becomes unenforceable. First, wrong onus is placed upon me. And second thing is, after all these years, it's just not possible. To the extent possible, I find a report. The report shows that they were not penurious. After that, also, the learned judge says, find out. Why should I find out?
And the union says that they have got income, 521. Union's letter 2024 speaks about they have got income.
I'll come to that. So therefore, at the end of the day, Manoj, what I wanted to show your lordships was one more thing, really, abeyance. Your lordships yesterday read the word abeyance and felt it was my order for abeyance. It is not my order for abeyance. It was the government of India who passed the order of abeyance. I had no control over that. That, my lord, will find at page 84.
84.
Hello.
What is my notice?
Do I not have 84? Now, 84 is a notice by Garden Breach, that is by us. Turn the page kindly. Paragraph 6. Recruitment of SM fourth phase. Management has completed 3 phases of recruitment as per the understanding with the union. The 4th phase of recruitment has been held in abeyance pending inquiry ordered by the government on the advice of Central Vigilance Commission. So this abeyance was not imposed by me upon them. It was imposed upon me by the government of India. So therefore, it's no fault of mine that there was an abeyance.
What is that order?
That order may not be here, but I've said this, I'll get it. I'm sorry, I should have it. But the point remains that this is my pleadings before the in High Court.
No further recruitment should take place. Page 93.
Which is this one?
This is the minutes of meeting.
Yes. But that is between, yes, that is CBO. It's a CBO, not binding on this government of India. 1 second.
But vigilance is there. Vigilance is mine.
CBO is not binding upon.
Vigilance is mine.
Vigilance is mine, therefore it's not binding upon me. That's what I'm saying. Number
As per the said advertisement, preference will be given such and such. It is also indicated the said advertisement in respect of which qualification they have declared such. Now, therefore,
kindly, just one moment. Kindly turn Manoj to page 128. Therefore, what? No,
therefore, the advertisement does not create any concomitant right in their favor for being engaged as a permanent employee. This is our speeding.
Our affidavit.
Yes, affidavit in
My lords have page 128 in hand.
Yes.
Turn to 134 kindly. This is the affidavit, my lords, by the Ministry of Defense in the first petition. And the irregularities are spelled out on this page 134. So
Yes.
it is not only a question of poor work, it's a question also of irregularities in the appointment of these people. Now, concededly, earlier it went through, but should I continue with these irregularities now also? So there were before the court several irregularities, even in the order before the division bench irregularities. Therefore, in simple terms, it's not I who stopped it. I was under the direction A of the CBO, then after the Ministry of Defense. Therefore, it was stopped not by me unilaterally. I have not chosen between one set of rules and another set of. I have been compelled by circumstances and by directions of my superiors. That is why it was stopped. Also, when the time it was stopped, there were irregularities which are enumerated. If the learned judge grants relief to these people, those irregularities will be sanctified and made correct, which is not possible. Now, I'll just make an observation as I go along. In any government appointment, it has to be done regularly. There can be no backdoor, as was laid down in Uma Devi's case. Now, here, if casual employees come before me, 400, 500 of them, and pursuant to an advertisement, if out of them, say, even 10% or 30% of them are these people, the DIH people, if I appoint them, am I not breaking Article 14? Am I not doing a backdoor method? You see, if they were regularly appointed, then that's an exception to 14 and 16. But if they are appointed in this manner, pursuant to an advertisement, then that is clearly violative of the fundamental rights, Manoj. And a government employment, which they have now got, cannot be got without following regular method of employment. If there are vacancies for regular appointment, those vacancies have to be filled by regular procedure. Any other procedure would be a backdoor entry. So therefore, let me put my submissions in line. If it is compassionate appointment in the real sense of the word, it is an accepted exception to Articles 14 and 16. But if it is not compassionate appointment, then it's a clear-cut break of Article 14. Also, it is recruitment without following procedure. It comes down to that. Having said all this, let us now go to the learned single judge. What is that? It's in volume 3, I believe. Volume 3. Let's have 609, volume 3. Well, before I read this, I just want to remind your lordships that the pleadings in this petition are entirely based on the 2006 MOM. In other words, they are claiming compassionate appointment in the year Manoj 2016 based on the MOM of 2006. And on what basis? On the basis that their rights were frozen in 2006. There was a bunch of workmen. It was said that these people will be given compassionate appointment in 4 phases. They say we have a right to the compassionate appointment in the 4th phase. There is no right in law for compassionate appointment, not even if it is genuine. Leave alone if it is over a period of 10 years. Now, in this context, Manoj, please turn to page 628. Do both my lords have that? On page 620, para 9 continues. Can you read the last 5 lines? Specific averments. Specific amendments were made in paragraph 29 of the affidavit in opposition to the extent that there was no scope for further recruitment, since clause 8 of the meeting dated so-and-so provides that the panel of dependents up to under death in harmony shall stand frozen on 31st March 2006. So they're claiming in the year 2016 on the basis of the frozen list of 2006. First of all, there cannot even be a frozen list. There cannot be a frozen list of compassionate appointees. Nevertheless, their case is that there is a frozen list. 1 to 3 phases were granted based on that frozen list. I have a right also to that post, and my submission is they have no right to that post now on the basis of compassionate appointment, especially once you find so many irregularities. Then let's kindly turn to page 12, sorry. I'm sorry, I got my paging on the basis of the internal paging. I'll just give you. I'll tell you. Well, page 632. From the bottom of the page, the last 5 lines, Reliance was also placed. Manoj, have that? Page 632, bottom of the page, last 5 lines. Reliance was also placed on order dated so-and-so, passed by the coordinate bench on a writ petition being so-and-so, wherein it was observed that the employment and compassionate ground was offered initially on casual basis and subsequently on availability of vacancies on substantive employment was offered. So now there is no dispute. The appointment was on compassion. Thereafter, the management has made those appointees permanent. But we are concerned today with the point of appointment. At the date of appointment, it was casual. The fact that the earlier chaps have also got permanency is not the issue. That doesn't confer upon them a right to compassion appointment. Now let us see the substance. Page 8, I'm sorry. Would you Lordship just look at the internal paging for a moment? On the top of the page. Paragraph 22. 638. We can leave that. I won't trouble my lords with that. Now, page 23. I'm sorry. What is page 23? Yes, page 642, 643.
So page 18, you didn't want to show anything?
No, that's all right. I'll leave it. At 643. Paragraph 30. Much emphasis was laid on behalf of GRSE to question validity of their own scheme. Here, Your Lordship will see, even at this stage, we were challenging our own scheme. Much emphasis was laid on behalf of so-and-so validity of their own scheme, which according to GRSE, sans approval of board of directors. But supplementary affidavits filed on behalf of GRSE reveals different situation. Para 4, the supplementary affidavit affirmed on 17 June 2010 contains statements that there was no irregularity and corruption in the recruitment process carried out under the 2006 scheme. There was total transparency in the acts and actions of the company. 2006 scheme was also defended that it was averred therein the recruitment undertaken was against approved vacancies, and such recruitment was approved by the board of directors. In the meeting, 266 meeting dated so-and-so, amendments were made in paragraph 4 of the supplementary affidavit that negate the submission of CRSE that exercise which is carried on appointment under death in Harvard was without approval of the board of directors and there was no sanction vacancies. Yesterday, my lord had occasion to ask us, where have we raised this negation? Where have we denied the fact that we have done something legitimately? In the same para, we have said, we deny the correctness. Then the learned judge picks up that affidavit of ours and says, no, but your affidavit says that you did it legitimately. That affidavit was 2010. This is 2016. This is the latest position, not that. So therefore, that was a mistake, and we have argued the mistake. It's not as if we haven't done so. The learned judge ignores the argument, there was a mistake, says, no, but you have said so, I'll hold you to that. Then kindly go, Manoj, further to page 24. Sorry. I'll just give you the correct page, 644. If one sees at the top of the page, line from the top of the page, line 5, said affidavit in opposition. Said affidavit in opposition clearly justifies the steps taken by GRSE in recruiting candidates under death and harmless category under fourth phase in terms of 2006 scheme. In spite of completing preparation of a select list, wherein names of petitioners herein featured, same could not be given effect due to objections raised by CBC. Now, I want to make one submission on this. A select list confers no rights. My lords are familiar with that. A select list confers no rights. So a select list can be at any time modified, countered, or removed. A select list is only an indication that these are the persons capable of being selected. And that's what happened here also. In the 2006 MOM, it was mentioned that we'll appoint so many this year, so many in the next year, and so many. So they were at best a select list. And a select list can always be varied or discarded.
Sankarshan Das.
I beg your pardon?
Sankarshan Das case.
Yes. I'm not sure the judgment, but I know the proposition. I'm not sure the judgment, but I'm aware of the proposition.
Das.
I'm obliged. Now turn to 645. On the at page 645, last 6 lines from the bottom of the page, in the backdrop. In the backdrop of facts that the petitioners were the empaneled candidates in the frozen list of 31st June for being appointed under death and harness category, and the said list could not be given effect to in connection with the fourth phase of recruitment process due to objection by CVC, and taking note of the aforesaid orders passed by the coordinate bench on 13th. It just stops here. I don't know. Next page. A committee was constituted on 2nd August 2014, which prepared a report as it was taken note of by the Honorable Division Bench in the order that is also passed in the contempt proceeding, but such report was not prepared following the 2006 scheme. Subsequent exercise made by GRSA as it emanates from the report signed on 13 July in terms of the order of the Honorable Division Bench does not postulate a situation that taking a note of 2006.
You are reading from which page?
I'm reading page 647, para 34.
647.
I'm sorry, ma'am. I'll read again.
You were reading 645.
I'm sorry, I've gone further now. 645 suddenly stopped. I don't know.
Yes.
I'm sorry, 646 is here. I'm sorry. Can we go back to 645 for a moment? I flipped 2 pages by mistake. Can you read back up 6 lines in the backdrop? In the backdrop of facts that the petitioners were empaneled candidates in the frozen list of 31st June 2006 for being appointed on the death and harness category, and the said list could not be given effect to in connection with the fourth phase of the recruitment process due to objections raised by CVC, and taking note of the aforesaid orders passed by the coordinate bench on 13 December 2011 and subsequently on 13 March 2013 passed by the Honorable Division Bench of the petitioners to be considered for appointment under death and harness category was crystallized in terms of 2006 scheme when 2013 scheme was not promulgated. Please notice the word crystallized. So they're claiming a crystallization of their rights. In saying this, the learned single judge has failed to realize the basic proposition of compassionate appointment. There can be no crystallization of rights in compassionate appointment. I trust I'm clear on that. Right. Then para 33. Order passed by division bench in the contempt proceeding dated so and so may have exonerated the respondent authorities from contempt, but that does not absolve GRSE in completing the exercise in terms of the order of 2013 as per the 2006 scheme. Once again, the learned judge has treated it as a recruitment process which was halted at one point of time. 647. On the top of the page, sorry. My lords have that, 647, para 34. A committee was constituted on 2nd August 2014, which prepared a report as it was to be taken note of by the Honorable Division Bench in the order dated so passed in the contempt proceedings. But such report was not prepared following the 2006 scheme. Subsequent exercise made by GRSE as it emanates from the report signed on 13 July in terms of the order of the Honorable Division Bench dated 14th May 2014 passed in MAT does not postulate a situation that taking note of 2006 scheme must be taken. Let's, for argument's sake, accept the proposition that it was done in the 2013 scheme. What have they produced today? They could challenge that if they wanted to. What have they produced today in your Lordship's court by way of writ to indicate that the position would be materially different had the 2006 scheme been considered? Nothing. Now, one thing is common in both schemes, that compassion appointment must be immediate. There is nothing in the 2006 scheme which differs from the 2013 scheme. And all that, and the authorities have gone right back to the DIH, which was in existence in 2006. So quite frankly, this is not correct to say it's 2013 that they've considered. They've gone back to the DIH register, which is 2006. So he has considered from that time onwards. Then para 35 after that. The ratio in NC Santosh Supra was decided in the background of facts of the amending proviso to Rule 5, which stipulates that in case of minor dependence of the deceased government employee, he, she may apply within 1 year from the date of death of the government servant, and he must have attained age of 18 years on the date of application. This was as per the rules. The rules permitted them to apply within 1 year. Then to the bottom of the page, kindly. Lordship finds the words NC Santosh in block capitals. From there, read on. In the context of the dependents applied for appointment under death and harness category when amended provisions became operational, requiring application made within 1 year from the date of death on attaining majority. But the case in my hand is glaringly different, as it is found that the petitioners were already selected to be given appointment on the death and harness category. Selected cannot be. Next page, carry on with that. 2006 scheme in 4th phase, but ultimately appointment could not be made due to objections raised by CVC. Therefore, in the present case, recruitment process was complete. Please note the words recruitment process. This is where the learned judge has gone wrong. He's treated this like a recruitment process. Was complete up to 3rd phase. Appointment was given to 170 candidates out of 213. Under death and harness category, but the petitioners could not be appointed due to intervention of CVC, whereas paragraph 10 of the NC Santosh discloses facts where application was made by the candidates on attaining majority when amended provisions became operational. Para 36, in Canara Bank, it was observed that the High Court rightly directed the appellant to consider the claim of the respondent by compassion appointment in accordance with the law and as per previous scheme then in existence. It was the case of the reconsideration of the claim of the candidates in terms of the particular scheme for appointment under death and harness category. But in the present case, entitlement of the petitioners were decided, leading to incorporation of the names in the frozen list. From the frozen list, 170 candidates were appointed on the death and harness category, excluding petitioners who were similarly placed. They are not. They are not similarly placed because they had to come to court even at the 4th stage and show there was an immediacy. Nobody can be in the same condition. The persons who were appointed in the 1st phase, 2nd phase, or 3rd phase had to show. They have not. But on a proper following of the law based on compassion appointment, there can never be a similarity between phases 1, 2, and 3, and 4. It can't be. Each case is individual. Each case has a death in the family and an immediate need for recovery. Yesterday, my lords asked me a question, how do you gauge immediacy? In my 2013 policy, I have pointed out that immediacy is based on the fact that you cannot survive tomorrow. Now, whether you have 1,000 rupees in hand or whether you have 10,000 in hand, you must be able to demonstrate that you are not able to survive the next day. That is the immediacy which the law requires. In such a situation, there can be no question of a list, there can be no question of an advertisement, there can be no question of selection. There's no selection. Then para 36, my notes. What's the time? time up.
Yes.
Sorry, and then we were at page 648, where I just pointed out that they were to be appointed as per the frozen list. Now see para 37 kindly. I could go through this judgment line by line, but there are two things your lordship will find throughout. One is that the stoppage was by the CBC. I want to emphasize that, not by me. The learned single judge has in several places said, okay, the work was going on, CBC stopped it. So I have not stopped it. There's no discrimination by me. I had to follow that. Not just CBC, but the MOD also. I had to follow that. Second thing is, if they demonstrate to me, okay, this is what is happening and please don't continue with it, then what should I do? Should I continue with it nevertheless? Because I'd given a frozen list in 2006. So therefore, this argument that there is a frozen list and that the CBC has stopped it is uniform to the entire judgment. Now then, if that is so, what is my fault? Then please turn to para 36, as I was saying. I'm sorry, am I troubling the court?
No. But it's the same thing.
It's the
There's
same
nothing different.
That's the same thing.
Ultimately, your case is that only which you have just now said. So,
Madam, then I won't trouble you further. This then is the judgment of the High Court. Now look at the operative part. At 658, my lords. No, I'm sorry, there's one more thing I wanted to show you first. My apologies. Please turn to 657. My lords have that, 647. For continuity of reading, we may read from the top about 7-8 lines from the steps.
yes.
From the steps taken by GRSE in order to give effect to the said frozen panel, dated 31st March 2006, and statement made in affidavit in earlier round litigation, it appears that the petitioners are similarly circumstanced like 170 candidates who were appointed on the death in Havan. Though it has been agitated on behalf of GRSE that the report prepared on previous occasion is not challenged in the writ petition, but such objection pales into insignificance as in the prayer of the writ petition, mandamus is sought for against an order rejecting candidature. So we have specifically argued this.
Yes.
Now please turn to the operative order, page 658. As it is found that from the letter dated so-and-so of General Secretary of GRSE Limited, Workmen's Union, that out of 49 petitioners, 30 submitted documents in support of their financial conditions. Rest 19 are directed to submit their documents in support of their financial condition within a fortnight from date before the chairman and managing director. On receipt of such documents, financial condition of the petitioner shall be assessed by the concerned authority or GRSE within a period of 6 weeks from in terms of the 2006 scheme, without insisting upon the petitioner to submit documents from Revenue Authority if necessary. Concerned authority of GRSE shall be at liberty to conduct door-to-door survey, and report shall be prepared within a period of 6 weeks, disclosing present financial condition of the petitioners. After preparation of such report, same shall be supplied to a petitioner within 7 days thereafter. If the petitioners fulfill the conditions in terms of 2006 scheme, they shall be given appointment on the death in harness category within a period of 4 weeks. Now, I am supposed to go door to door after 16 or 20 years and find out whether in 2006 they were in penniless condition. If they were, and they have survived so long, the Supreme Court says that can never be penniless. If they've survived from 2006 to the date of this judgment in 2024, then there's no question of penury. And why am I given the job of going door to door? Should they not be coming to me? Lastly, is there not a report before the learned single judge indicating clearly that they are not penniless? Is there not a report before the learned single judge showing that none of them are entitled? He ignores all that. As far as facts are concerned, I am done.
Which judgments you are relying upon?
What I was thinking is that I will carry my bunch of judgments, make a compilation of them so that, no, compilation only of the principal points, so that we don't read the entire judgments. I will do it today if necessary. But I don't want to.
We can complete it today. That's why we had
But
kept it.
there are a fair number. I don't mind. But you'll
Just give us the judgments. We'll tell us the judgments that you are relying upon. The paragraphs, we'll consider it. You need not read the judgments.
No, I was thinking of making a small compilation of only the principal points so that we don't go through the entire judgment, but I could emphasize certain points which I wanted to
No,
emphasize.
the points that you are arguing, we have taken note of. So the judgments
Shall I
can
give
be.
the citations to your Lordship's learned associate, or shall I file that document as a compilation? We have the copies ready. But
So we can take it up immediately after the recess and.
Shall I argue them in brief, therefore? Or I want to emphasize certain aspects of those judgments, that's all.
Basically, you will be relying on judgments to argue the very settled principles. That is whether after a delay, concept of immediacy, and whether it is an enforceable right, exception to Article 14, all these things.
What is meant by immediacy? Supreme Court has held immediacy means hand to mouth.
Correct.
They use that phrase. And the court also says that there can be no regularization.
All these submissions that you are making, there can be no other view possible.
So I was only
These are very settled principles of law. So which judgments you rely upon, we can go through it briefly. Because the only thing is whether those judgments will apply or not. The principles are cannot be disputed even by the other side. These are very well settled now through various judgments.
Yeah, the side, my lord, with great respect, is relying on this frozen list. So they are not going to accept my judgments.
Therefore, we are saying those principles need not be emphasized. They are well settled. We are looking at these principles every day. The point is whether in the facts of this case it applies or not. There will be a variance between both the stand taken by both the parties.
Whatever your lordship pleases, we'll do it. We'll give it to your lordship's learned associates. Or can I give it to you now? Because
Can we continue and finish it today? Because we were under the impression that you will conclude today. You
I
had said.
concluded facts.
So you can cite the judgments after recess. We'll give you another 15-20 minutes.
Permit me to.
We have original side matters fixed at 2 p.m.
Permit me to assist the court by making them very short. I'll give you as a short compilation. Judgments I'll give today, no issue. But give me an opportunity to make the court's job easier.
Speaking for myself, I am reluctant to take compilations and notes after the argument.
That's right. But
if you give it beforehand, then we can follow it up.
Very well. Should I give it to your lordship just
You give the notes, then we can consider the judgment. Because see, if there is something stated in the notes which you did not argue, then we will not consider it.
Very well. Then may I have liberty on next occasion, whenever it is, to at least make a half-an-hour submission on those judgments. That's all.
Yes. When do you want? Tell us.
Give the citation and the judgments to your lordship.
Oh, you come with the notes and you make your submissions that day. No problem. Half an hour we'll give you.
I just thought I'd make it easier for the court.
You may do as you please. When do you want it? That you tell us.
Monday.
Monday it will not be possible. Monday, Tuesday it will not be possible.
May I just have a look?
Friday. देखो अच्छा सुप्रियो
Just one moment. Okay. No, you have time? Yes, I'll be here. But my only
2nd of September. The time fixed? Any time be fixed, my lord?
Original side matter item number 1.
My lord, item number 1, my lord, I am appearing for the respondent. My lord, there is one predicament for which, my lord, I am seeking for adjournment for some time. My lord, the chamber of the learned advocate on record for the respondent, my lord, his chamber was there in the Mirza Ghalib Street in the building which burned down. So, my lord, the fire department has sealed the building, and my lord, as a result, the chamber is also sealed. So, we do not have access to any of the, my lord, briefs or documents. So, my lord, will kindly adjourn the matter for some time. My lord, it is sealed since 19th. My lord, we have, my lord. My lord, meetings have been held. My lord, we are trying to get the access to the, my lord, chamber.
How can they seal a lawyer's chamber with all the files?
My lord, they have, my lord.
That's
My lord,
what we
I
are
have.
saying. You have taken no steps.
No, my lord, we have, my lord. We have given them a letter. We have also, my lord, sat in meetings with them.
We are not going to record all these things. How much time you want?
My lord, will kindly give me 3 weeks time, my lord.
It's coming up for the first time.
On the last occasion he appeared, my lord, I could not appear before your lordship. I tendered an unqualified apology. My lord was pleased to fix the matter after 3 weeks. That is the date fixed today.
So it's being listed only to be adjourned on every occasion. The learned advocate for the
Item number 2.
yes. 2 times. Again, today there is nobody.
Same matter, no? 2 or 3? No. Yes.
Where the orders? Give the orders.
Item number 2.
Show the orders. Order book. Come up for the first time. Confirm.
Two.
None appears for the parties.
Item number three. Three, my lord, I appear for the respondent number one, my lord. This is an appeal arising out of an order dated 8th February 2024, my lord. To cut short the matter, my lord, there was a direction to pay the subsidy of in terms of the West Bengal incentive scheme of 2008. Now, on 2nd April 2025, the West Bengal government introduced an act that is revocation of the West Bengal incentive scheme 2025. Now, that very act has been challenged by 19 writ petitions, and that is under hearing.
So this has nothing to do with the subsequent act. There is a liability which the court has adjudicated. You have to pay it.
Yes, I am the respondent number one. I will get the payment. I am not the appellant.
So how the subsequent act is relevant?
My lord, they have said that retrospective effect. So, my lord, no money will be given to that. As the scheme has been revoked, no money will be given. That is the act. That act has been challenged in this writ petition. My lord, kindly see the orders.
The act has set aside the High Court order also.
The act has set aside the scheme itself.
We are not on the scheme.
But under the scheme, I am to give the money. I have to get the money.
From what we could gather, there is already an order to make the payment by the court.
Yes.
Subsequent act. We are not challenging. You have not challenged the subsequent act.
But I personally have not challenged, but other writ petitions have.
They may have. That is not relevant for you.
That act is under challenge now. If the act goes, this could be go on. But I think the appellant would come and show the act itself that the scheme has been revoked. As the scheme has been revoked, nothing remains. They will say. That was the stand on the 2025.
You should be trying to convince us that revocation of the scheme means nothing.
I want to, but that will be the.
But you are.
That will be the point of the appellant, my lord.
Forget about what they will say. Why you are worried about what they will say?
This was the point taken in 2025, my lord. This matter was taken up that also.
So still you are not prepared to the contrary. You are still making a submission what they have
prepared.
said.
My lord would see 8th February 2025 4 orders that would suffice. The impugned order itself suffice.
Argue your own case. Forget about what they want to say.
But that was the stand taken out by the appellant. I have to be very candid. I showed what the stand was taken by the appellant.
You accept that stand?
No.
That's why you are saying you either you accept it or you.
I do not accept
don't.
that stand.
Yes.
There is a court order directing them to pay.
Yes. They have been appearing on the earlier occasion.
Yes, on the earlier occasions they have been appearing. This is appearing for the first time after a period of 2 years, 1 year.
So they are entitled to one adjournment on the first day.
No, my lord. I had indicated the true form what has happened. I don't want to catch it off guard.
There is his lordship is rightly pointing out, perhaps there will be a change. If you would please lend us your ears also for some time. His lordship is perhaps rightly is observing that there might be a change in the panel. Earlier, some other lawyers were appearing.
The panel has changed because the state government has. But the appeal is theirs. It is their right to appear.
They have to keep track of their matters. I have directed for. Whoever is in charge, they should. Do you know who heads the panel now?
For the state, it was appeared, the AG had appeared for the state in the writ petitions. WB IDCL Sujit Shankar Kole had appeared before the writ court.
We are asking you, do you know who heads the panel for this corporation today? We don't know whether now AG will appear or who will
For corporation, Sujit Shankar Kole had appeared.
Not had. We are asking you, do you know who heads the panel today?
Had appeared, I mean on 8 July 2026 had appeared before the writ court. That is after
July.
Yes, that is after the
Tell
change.
him, intimate him. You tell him.
That is why I am showing this order.
Tell him.
You are suggesting that just inform.
I can do that. I can do that.
Fixing the matter after 3 weeks.
Very
In the meantime, just inform me.
I'll serve a notice.
So it is up to you, sir.
And I'll serve a notice.
But please inform me. Otherwise, the wastage of time will.
I'll serve a notice. I'll serve a formal notice. I'll serve a formal notice.
That's great.
Same position tomorrow, or tomorrow then. Let it be at the same position. On Thursday, tomorrow. Come tomorrow.
2 p.m. at item number 118.
Last day's difference, look at last year's notes. Yes.
Last occasion I stopped after citing Circular 21 of 1984, Millard. After that, Millard, I was supposed to place, Millard, the Food Corporation of India Contributory Provision Fund Regulations, that is Annexure P3 at Millard page 629. That would be volume 5. Prior to that, Millard, prior to coming to that, Millard, two more factual aspects, Millard, I would like to, Millard, highlight, Millard. That will kindly take, Millard, volume 3 once more. Millard, in volume 3, Millard, there was, Millard, Russia will kindly, Millard, take page 348.
Yes. Give us a minute.
Yes.
Yes. Page?
Page 348. Why I'm placing this, Millard? Because, Millard, when the writ petition was being heard, the learned single bench, Millard, made certain queries.
Yes.
And those queries were asked to the appellant, Millard,
Yes.
where the appellant, Millard, in turn went back to the Millard. The department sought clarification, and on the basis of the clarification, this reply was given, Millard, which was part of, Millard, an affidavit by way of a report by way of an affidavit, which I will again place, Millard, and then I will go to the 67 regulation, Millard, 67, Millard, at Millard page 629, Millard. Prior to that, Millard, this is again is a part of the second supplementary affidavit, Millard, which I placed earlier, Millard, on the last occasion, which was at page 316. of volume 3 I am placing 348 of the same volume That will kindly take this document Subject Lordship would see reputation number such and such, অবসরপ্রাপ্ত ভারতীয় খাদ্য নিগম কল্যাণ সমিতি and another versus Food Corporation. Now the subject is thereafter please refer to our letter dated 7/7/2023 to subject cited above in regards of queries raised by Honorable Justice Raja Basu Chaudhary in High Court at Calcutta. The details are as under. First query, whether the office memorandum dated 1st May 1987 as has been issued by the Government of India is applicable to FCI, or has it been adopted by FCI for its employees, that is food transferees from the Government of India services. Reply is employees transfer to FCI opportunity. Why is the query? Why the answer is like that? On the last occasion, when I was submitting, there were options were given to the central government employees, to either retain pension benefits, of the central government, or come within the contributory provident fund scheme, which is, I'm sorry, central government, or under the liberalized pension scheme,
What is the I see how orders it is all folded. It will get gone. No sense of keeping records. Just can't maintain.
Yes. Yes.
Second query was whether any of the food transferees from the Government of India service as the central government employees, in FCI has got the benefit of changeover from CPF to pension scheme as has stated in the above OM, that's office memorandum. Was there any cutoff date for that? Reply is no. This is our internal document, but we disclosed it before the court, because the query was raised, Third was, what is the implication effect of the document number government letter to FCI dated 15/2022, being such and such dated 15th of February 22 upon the employees FCI including food transferees and absorbed deputation is other state government employees, who now is before your lordship as the respondent writ petitioners, Lordship will kindly see the answer in pursuance to GO dated such and such, circular number such and such was issued by FCI. I will come to those circulars, thereafter, Now Lordship will kindly take, the circular, at page 350. The third query, which, this is the circular, that was referred to. Enclosed, please find F number such and such dated 15/2021, should be 2021, probably the date has been mistaken. Issued by the Government of India, Ministry of CAF, Food and Processing Department, Food and Public Distribution, regarding revision, rationalization of pension, family pension in respect of IDA food transferees who opted for central government pension, which is self-explanatory. So anybody has to be a central government employee and not a state government deputationist, And I'm sorry. And this, is in consonance with the statutory modification or the inclusion of the statute under 12A4A. That is the inclusion in the statute creating the class within a class. Now, my lord, kindly comes to page 351, my lord.
After all, these replies only reflect the position as existing from the rules.
Precisely, my lord. Precisely, my lord.
This will not create or this will not take away any right from anyone. These are replies based on that.
Yes, 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 yes.
Ultimately, we have to see whether 12A as it is and what is the effect of the agreement.
Precisely.
These are the two things.
Precisely, my lord. Now, one more document. Why, my lord? I'm sorry, my lord, but probably it's a repetition, but what I'm trying to espouse is that the possession of the deputationist vis-a-vis the possession of the food transfer, deputationist who are absorbed and the possession of the food transferees are completely different, because both are different classes within different statutory parameters. And millet, if it is a different statutory parameters and different classes are created within different statute, different regulations, cannot be millet clubbed and said millet, that are at par and standing in the same footing. Millet, I will millet, cite millet, some millet decisions on this millet. Now the violation would have been millet. Thankful, Mr. Chakraborty, millet. The violation would have been if millet, the food transferees who are the central government employees, the deputations who are absorbed, state government employees are inequally treated, because the state government employees once absorbed, if they are treated inequally, then it could have been stated that they are being treated unequal because they are otherwise equal. But here the case is completely different, because the central government food transfers exercise the option to accept the liberalized pension scheme under FCI or wanted to stay back under the original central government pension scheme, have had the right to exercise their option twice, and by the dint of Circular 18 of 1984, whoever has applied the state government deputations who have come FCI direct recruits govern 7 regulations, which are as equal, because are statutory forces and both are differently placed and differently positioned. Positions differently. That is the reasonable classification that has been created by the statute, and the statute cannot be overlapped. I cannot bring the 71 regulations, if somebody is governed under the 71 regulation within the section 12, vice versa. This is my short point in law, and may I take back your lordship to more documents, and then I will go back to the 67 regulation, and then
Which document?
Page 351, Millet.
We can look into these, but these are all your replies. These cannot be made the basis of determining anybody's rights.
No, absolutely, I agree.
Therefore, we are saying ultimately it is all submission is based on what we have heard on the last day. What you are
yes, Millet. I would agree.
So this is only reflecting that which you have argued on the earlier day in the course of the.
I will come. I will not trouble your lordship. Then, Millet, I will straight away, Millet, take your lordship, Millet, to. Yeah. Yes, Millet. Now, interestingly, one document, Millet, since Millet, lordship had been, why I was placing him, Millet. There's one, because of this, Millet, to be placed similarly, Millet, there was one SLP that was filed, Millet. That order, Millet, I need to place, Millet. That is at page 353, Millet. The document at 351, my lord, mentions with regard to, my lord, the Supreme Court's order of 28/10/1991, my lord. That is at the bottom paragraph at page 351. Further, starts with the word, I'm sorry.
Further.
Sorry,
Yes, no. We are unable to keep up with you.
I'm sorry, my lord. That's the difficulty of being more into devices, my lord. But good thing of for your lordship is, my lord, if this crashes, my lord, I'm as blind as a bat.
Why is it good for us? It's bad for us.
Bad for me, but good for your lordship is because your lordship is still in the old school, my lord. Still can flip pages. But I have no other way to go. Paragraph 3, my lord, of that document, my lord, at page 351. Further, it is submitted that aggrieved by not allowing them to switch over from contributory provident fund scheme to the liberalized pension scheme of the central government, they had earlier filed a writ petition before the Honorable Supreme Court, and the Honorable Supreme Court video order dated, judgment dated 28/10/1991, copy attached for ready reference, dismissed the petition stating that the petitioners had already exercised their option for CPF scheme, which was final and as per the act, and therefore they are not entitled for benefit of pensions. So Supreme Court, it once traveled to Supreme Court by way of an Article 32 application. That order, Lordship will find at page 353. It's slightly gibberish. The typed copy is at the next page at page 354, my lord. Passed by my lord Justice Singh and my lord Justice Ramaswamy, my lord. The question raised in the present petition is squarely governed by the constitutional bench of this court in Krishna Kumar and others versus Union of India 1990. There's a citation, my lord, to the judgment today, page 173. The petitioners are not entitled to benefit of pension since they have already exercised their option for contributory provident fund. There is no merit in this writ petition, accordingly dismissed. So this point was earlier agitated by a different group of people, my lord, and Supreme Court, my lord, had already dealt with this point, saying that they cannot switch over from scheme A to scheme B because they have exercised to remain in scheme A. So perhaps, my lord, the learned single judge, my lord, while, my lord, passing the order, my lord, perhaps has not adhered to the observation already, my lord.
In present case also they gave an option to stay.
Yes. That is precisely our case, that 66 agreement, then 84 circular, my lord. Option was given under the circular, my lord. Option form was given. Once you apply through that option form, the state government deputation is being observed. They will be governed under the 71 Food Corporation regulation.
Where have they given an option? When they were given an option that you have to select between a CPF and a liberalized pension scheme?
Yes.
Show the document.
That was the circular 84 I was citing.
Where is it? Let us see.
Yes.
One more. 323.
Just a second.
Now you have to keep up with us.
Is this way or that way?
Yeah.
I'll just
323. Come to
I'm grateful.
Where does it say about CPF?
Yes, my lord. Now, my lord. Here, my lord, it speaks of, my lord, second, the absorption of employees will be subject to the following conditions. The state government employees who opt for permanent absorption in the service of corporation will be treated as direct recruits and will be subject to the terms as conditions as prescribed under the FCI staff regulation of 71. Now, the staff regulation of 71 consists of the contributory provident fund scheme, my lord. CPF is a part of the 71 regulation, my lord. Now, my lord, thereafter, my lord, they will count their seniority. I am not on that, my lord. Details indicating the post and scale of pay. I am not on that, my lord. West Bengal state government employees who.
Yes, you had shown this. You
Yes.
relied on 3 to say that for a period prior to their coming here, they will get a pro rata pension
Yes.
from the state to be borne by the state.
Yes, yes, yes. Precisely, my lord. That was my argument, my lord.
Yes.
Now, my lord, I will come to my lord. Annexure P3 at page 629, that's volume 5. This is the Food Corporation of India Contributory Provident Fund Regulation.
Page
629, volume 5. This is where, my lord, I stopped on the last occasion where Lord Lordship had to rise, my lord. Lordship got the page, my lord. Kindly see, my lord, regulation 1 within bracket 3, they shall apply. 1. To all employees of the corporation regularly appointed to its service under subclause A of clause 1 of regulation 7 of Food Corporation of India, staff regulation 71.
Yes.
I'll come to 7 a little later, my lord. Let me first.
Sorry, I missed. Can you please again tell us
Yes,
what you're reading?
Lord, I said, my lord, the first 3 conditions that to whom it will apply, my lord.
1-3. You're referring to 1-3.
1-3 Roman 1.
All right.
To all employees of the corporation regularly appointed, that's the direct recruits, to its service under subclause A of clause 1 of regulation 7 of the FCI staff regulation 71. That's 1. 2, Roman 2, all employees of the corporation appointed to its service under clause B of subclause B of clause 1 of regulation 7 of the staff regulation 71, other than those who opt for pensionary benefits of the government. 3, to deputationists absorbed permanently in the service of the corporation under subclause C of clause 1 of regulation 7 of the staff regulation. Now the writ petitioners are admittedly deputationists, so they will come, this will apply clause 3. Probably the deputationists will come in. Because it's specified, it's clearly mentioned here that deputation is absorbed permanently. So permanently absorption happens under the circular of 84. Once I opt, I come under 133. I am not on 4 and 5, my lord, then I will straight away, lordship, take your lordship to regulation 7. Regulation 7 is food transferees, my lord. A food transferee will be admitted to CPF only if he has either specifically opted for FCI regulation or failed to exercise necessary option within the prescribed period. The heads of office will furnish a statement to head office in respect to food transferees to be admitted to CPF. These statements should give, besides the information contemplated in the form the previous GPF account of the transferee, the name of the pay and accounts office, etc. Malad. This is Malad, the provisions regarding to the food transferees, Malad. I will Malad skip here, Malad. Now, Lordship was mentioning, Malad, the period here, Malad, it has this provision categorizes, Malad, that once if he has specifically applied to opt for the CPF income, if it is not exercised, Malad. Categories, Malad, one, they have, Malad, clarified this, Malad. Now, Malad, kindly take 622, Malad. First we got 622, Malad.
Yes.
This is the section, Malad, which governs governance to the corporation in certain cases, Malad. 12A. Again, Malad, I had to place this, Malad. One, where the central government has ceased or ceases to perform any functions which under section 13 are functions of the corporation, it shall be lawful for the central government to transfer by order with effect from such date or dates which may either be retrospective to any date not earlier than 1st January 1965 or prospective, as may be specified in the order to the corporation, any of the officers or employees serving the government of the central government, dealing with food or any of its subordinates or attached offices and engaged in the performance of those functions, provided that no order under this subsection shall be made in relation to any officer or employee in such department or office who has, in respect of the transfer such officer or employee to the corporation, intimated within such time as may be specified in this behalf by that government his intention of not becoming the corporation. So a transferee has that option of not becoming an employee and retain its pensionary benefit of the central government. That clarifies, Millet. Taking an order of the subsection 1, the central government shall as into consideration the functions which the central government seized or ceases to perform and the areas in which such functions have been or are performed. 3. Officer or other employees transferred by an order made under subsection 1 shall on from the date of transfer cease to be an employee of the central government and become an employee of such designation as the corporation may determine and shall subject to the provisions of subsection 4, 4C, 5, 6 to be governed by the regulations made by the corporation under this act as respects pension, remunerations of service, including pension. By the corporation. Now, 4 is the one, Millard, where this whole story, Millard, stands, Millard. Every officer or other employee transferred by an order made under subsection 1 shall within 6 months from the date of transfer exercise his option in writing to be governed. This is only specified to the central government, Millard. May I reiterate again, Millard? By the scale of pay applicable to the post, immediately before the date of transfer, or by the scale of pay applicable to the post and the corporation which he is transferred. I am not on that. I am more on, Millard, B, by the leave fund, retirement or other terminal benefits admissible to the employees of the central government in accordance with the rules and orders of the central government as amended from time to time, or the leave fund or other terminal benefits admissible to the employees of the corporation under the regulation made by the corporation under this act, and such option once exercised shall be final. So, Malit, this is the fine distinction, Malit, which the regulation I showed, which is the 67 regulation, which says that it will govern the staff regulation will be governed, the contributory provident fund regulation, Malit. I will come to the staff regulation once, Malit. That would be easier for your lordship, Malit, to it would be easier for me to explain, Millard. And this is, Millard, the act which, Millard, segregates, Millard, the central government employees, Millard. Staff regulation ta kon page hai? 12 of which regulation? I'm sorry, Millard, this one more page, Millard, page 624, if your lordship kindly takes, Millard. That's the 4A, the provision 4A, Millard. Every officer or other employee in respect of whom an order of transfer under subsection 1 has been made before the date of commencement of that Food Corporations Amendment Act 1977 shall, whether or not he had exercised the option under subsection 4 before the appointed day, exercise such option within 6 months from the appointed day. So the second option was given to them. Every officer or other employee respect of whom subsection 1 after the appointed day shall, within 6 months from the date of such order, exercise his option under subsection 4. So central government, Millet, to summarize, the central government the given options twice, earlier ones, and then through amendment, I'm sorry. Accent. নোটটাই দেখছি আমি। Staff রেগুলেশনটা চাইছি আমি, FCI staff regulation 71 রেগুলেশনটা চাইছি। এবার কোথায় আছে, কোথাও একটা আছে, আমি খুঁজে পাচ্ছি না। Yes. Yes, Milan. No, page. Yes, Millet. Now, Millet, I was citing Millet page 631, Lordship, one document, Millet, That is at page 632. That is the Food Corporation of India Staff Regulation, 1971, milord.
Yes.
Yes, milord. But we will kindly take Regulation 3, milord. This,
yes,
they shall apply to all employees of the corporation, including transferred employees, other than persons employed on purely part-time basis, person employed on special contract to the extent that the terms and conditions of such contracts are inconsistent with the provisions of this regulation. C, persons governed under the Industrial Employment Standing Orders, milord, and the Food Corporation of India Industrial Establishment Standing Order, provided that nothing contained in this regulation shall apply to any director of the corporation or secretary, milord. So, milord, here, milord, in the staff regulation also, it, milord, limits, milord, govern. In this staff regulation, nowhere it is mentioned that the central government employees or the transferees will be covered under this, milord. It is, milord, employees of the corporation. The food transferees, in my respect submissions, comes under a completely different category, milord, completely different, milord. It's a creature of a statute and an amendment which was brought by way of a statute, milord, and nothing else, milord. So that they will not be covered under the staff regulations of 71, milord. They are completely different, milord. Whoever is under the staff regulation of 71 will be covered under the Contributory Provident Fund Scheme of 1967, which I, milord, earlier showed before your lordship, milord, which speaks of the different categories of, milord, employees who covered under that, milord. Now, milord, one argument that was made, milord, before the red court, milord, I will only, milord, place two more documents, milord. First is, milord, there is one judgment that
so this 71 does not apply to the petitioners.
71 applies for the petitioners. The 12A does not apply for the petitioner. It's slightly confusing, milord, because
It's not confusing.
For me,
We thought that you said it does not apply.
No. I say it does apply, milord, not the central government. It does not apply for the central government employees.
Very clear. It says only these two classes are excluded.
Yes. Milord, grateful, milord. Now, milord, one judgment, milord, was constantly referred, milord, reported one, milord, Ashish Ganguly versus Food Corporation of India. That was, milord, referred, milord, and in that
ওটাই দেখাচ্ছি
This judgment, Milad, Ashish Ganguly versus Food Corporation of India, Milad, this was, Milad, referred, relied upon, and the learned trial court also, Milad, kind of, Milad, based reference while passing the order, Milad. Now, Ashish Ganguly's judgment can be distinguishable on the pretext, Milad, that it, Milad, only encompasses, Milad, regulation 81 of the West staff regulation of 71, Milad. Now, may I read what is regulation 81? The case of Ashish Ganguly was purely in that aspect, and it has no semblance of connection, Milad, with regard to the prayers in the writ petition of the writ petitioners, Milad. Lordship will kindly take page 633, Milad. Regulation 81. Pay on first appointment. The pay of an employee on first appointment to a post in the service of the corporation shall be fixed at the minimum of the time scale applicable to the post to which he is appointed, or where the post is on the fixed pay, such fixed pay. Provided that where any person appointed to a post to which a time scale is applicable has been in continuous service for a period of not less than 2 years in any department of the central or any state government or any public sector or private sector undertaking immediately preceding such appointment, the appointing authority may in its discretion fix the pay at the stage in the time scale applicable to the pay of the post next higher than the pay last drawn by him in such department or undertaking, and may in addition discretion grant one advance increment. Further, that the management start direct recruitment, direct recruitment up to consultation with the executive director of finance of the executive committee may grant such advance increment in excess of the above limit, provided also that in no case shall the pay be fixed at a stage higher than the maximum of the time scale. This is the crux with regard to Millard, the matter which traveled up to the Supreme Court. That's Ashish Ganguly Millard. Now we are also
Central government employees. In Ashish Ganguly?
Yes, that was a central government employee. Ashish Ganguly was not a state.
Actually, they have
State government employee. It traveled up to the Supreme Court, Millard, but it is on the pay on first appointment. The prayer of the writ petitioner.
This 81 is only reiterating the concept of FR 22. One advance increment given because of, normally it is given when there is a promotion or a transfer to a higher post.
Yes.
And in exceptional circumstances, 5 advance increments.
Yes.
That
But
also by the
yes.
board and executive director.
Yes. But the case of the writ petition before the single bench.
Want parity in terms and conditions of service with those who have come from the central government.
Now, may I?
Including pensionary benefits, everything.
Only pensionary benefits, nothing else. Kindly see their prayers. Kindly see their prayers.
So perhaps that is only disparity. Is it your case that they are getting a different salary also?
Yes, indeed. Because the central government had the option of keeping their original salary, which they used to get under the central government. If they exercise the options, they will come under the pension scheme, liberalized pension scheme.
We are not on pension.
Yes.
We are saying, can they be the salary that those who have come from the central government, they are getting, whether the petitioners are getting salary in the same
No.
Of central government, then otherwise they
Central government or state government salary is same.
salary same. যদি না তারা offer করে।
Unless they opt the same. That's my
That's
instruction.
what we are saying.
Yes,
It
yes.
has to be. Insofar as the pensionary benefits is concerned, there is a disparity.
Yes.
Otherwise, perhaps they are all at par.
Yes. Now, Millet.
Is there any dispute on that account? It's only regarding the pension.
Only the pension. That will kindly take, Millet, page 51 of the writ petition, Manju. Of the paper book, Millet. First volume. Page 51, first volume, first volume.
Yes.
But we'll kindly see the first prayer after paragraph 50. Application is bona fide, Millet. Thereafter, Millet. In the facts and circumstances, your petitioners pray. A writ and or writs in the nature of mandamus do issue, commanding and directing the respondent authorities to show cause as to why the respondents would not be directed to extend the petitioners the benefit of liberalized pension scheme as formulated by the central government.
What we thought, that's why we asked you. Perhaps there is only a disparity on this score.
Yes, and no other dispute, Millet. Now, my case is solely on the premise that this parity cannot be given, Millet, because Millet, I am not in a position to give that parity because there are government regulations, one statute and one regulation which governs these two different classes, Millet. But there is already reasonable classification that has been by the FCI Act, and also, Millet, after they had opted the option through the circular of 1984, they come under the contributory provident fund scheme, which is governed under the FCI staff regulation of 71. And they have not ever, Millet, have challenged the virus of inclusion of this provision in FCI Act, Millet. They have never challenged, Millet, the CPF regulations of 1967, Millet, which basically, Millet, is the backbone of the staff regulation of 71 as to how it has to be governed, Millet. This is the whole premise, Millet. That will kindly see, Millet, at page 52, on the basis of the recommendation of the 4th Central Pay Commission as extended to the employees absorbed from the central government service and on failure to show cause to be. So, Millet, they cannot be placed in the same pedestal, same footing as the central government employees when they have opted for this option pursuant to the circular number 21 of 1984 and have exercised their option to become absorbed within FCI and become recruits at par as the direct recruits of FCI and will be governed under the contributory provident fund scheme. The second prayer is a certiorari, Millet. Third is to consider, Millet, etc., etc. Millet. This is the short prayer, Millet. This is the short premise of the matter, Millet. Even, Millet, when in the written notes, Millet, I'm sorry, Millet, I'm taking your lordship back and forth of the documents, Millet. Kindly take, Millet, page 36. And I'm sorry, Milan.
Yes.
Very sorry, Milan.
No, no. No need to be sorry. Yes.
Bad habits, Milan. I know Milan Justice Ray knows me well for some time, Milan. He knows all my bad habits, Milan.
I have gained more insight into the bar recently. Yes.
But we'll kindly take Millet, page 361, Millet.
Yes.
That is there, Millet. That's volume 3, Millet.
Filed by them.
Yes. Kindly see the first paragraph, Millet. The members of the petitioner number 1 were initially the employees of the government of West Bengal in the Department of Food and Supplies as sub-inspectors and other posts. By an agreement 26 November 66 entered into by and between the government of West Bengal and the FCI, the employees of Foods and Supplies Department, including the petitioners, were sent on deputation with FCI from 12th December 1966 and on subsequent dates since the public distribution system has been altered, a statutory body was being roped under such purpose. Matter pertaining to the recruitment of staffs in the FCI is governed under Section 12 of the Food Corporation of India Act. In 1968, Section 12A was inserted so as to enable the central government to make an order directing its employees to be transferred to the service of FCI. Those employees who are working as transferees from the central government were absorbed. Subsequently, the members of the petitioner number 1, being the employees of the state government, were absorbed with effect from 1st July 1984 in terms of a circular dated 19th March 84 upon tendering resignation in their parent cadre. In the option form which was appended to the circular, there was a condition that upon absorption they would be treated as direct recruits and be made members of the CPF under Contributory Provident Fund Regulation of 67. I pause here, my lord, and say, my lord, once you have exercised this option of 67, come within the purview of 71, you cannot ask parity under 12A, 4A, my lord. That is my shortest case, my lord. To cut the entire 2 days story to a one-liner, this is my case, my lord. Only on the point of pension, my lord. I'll pause here, my lord. I will come back with 3 decisions on the next day, my lord. Give me this, my lord, liberty, my lord, to come back. I can come back on Thursday only, my lord.
You have not come with judgments today.
No, my lord. I thought I would take some more time, my lord. I beseech you, lord.
We were expecting that you.
And Mr. Kaur is also, I actually spoke to Mr. Kaur. Mr. Kaur is also representing the High Court administration in another matter.
You are here.
I said that I will not say a word because somebody who has conferred me with something, Willard, if they wanted to want it back, I'm readily, happily want to give it back. I have no problems, Willard. That was my constant stand, Willard. what I can do is, Millet, I can just like, আমি এখন other side কি বললে তারপর তো
Which judgments you are relying upon?
Millet, Millet, I have done a little bit of research, Millet. I can just hand over.
Canvassing which points?
Only on the point of reasonable classification.
Classification,
Yes.
that's what we were saying.
Yes.
Must be only on the classification. Whether the classification is sustainable or not. And whether they are in a position to challenge the classification
Yes.
in
Only
view
on
of the
that
way
point,
that
Millet,
they have progressed.
Lordship would recollect this one judgment, Millet, this one of celebrated ones, Millet, that is the Paradip Port judgment, Millet. It's cited in up to the Supreme Court, Millet. The Inland Water Department, Millet, of Government of Odisha, Millet, they were on deputation, Millet, and they asked for parity, and up to Supreme Court it traveled, Millet. I want to cite that and one more judgment, Millet. Two judgments, not much. Here I do not remember. Well, I'll just come back with the correct.
At least give us the judge, if you know the judgments that you have.
One more judgment, Millet. I can. And the Ashish Ganguly's judgment, Millet, subsequently, Millet, was, Millet, distinguished by the Honorable Supreme Court in, Millet, Civil Appeal number 894 of 2020, Millet. It's a reportable judgment. Millet Justice Mishra, was presiding over the bench, Millet. UP Roadways Retired Officials and Officers Association. I'm sorry, Millet.
This is the Civil Appeal 894.
Yes. Versus State of UP and another, Millet. I will give that reported one, Millet, and also, Millet, the one I was mentioning, Millet, Paradip Port one, and this one more judgment, Millet. Any day, Millet, Friday 2 p.m. I will take 10-15 minutes, and then Mr. Kaur can, Millet, resume his arguments, Millet. Thursday, actually, Friday.
Yes.
I'll come back on Friday, Millet, 2 p.m. Millet. I will take 10 to 15 minutes, Millet. I will only show the relevant paragraphs, Millet, and then Mr. Kaur can take over. Can
you continue on Friday?
Yes, we'll start, Millet.
Keep it at 2 o'clock, Millet. I will be armed with.
Can we
threes.
conclude on Friday?
Yes, Millet. We won't take more than 20 minutes, Millet. The issue is
Then
very
we
short.
will apply on Friday itself.
Yes. I will do that. Grateful. The frame your lordship was wearing on 15th of August. I actually wanted to ask your lordship, will it 2 p.m. or not? 2 p.m. 2 p.m. No, okay. Wonderful one. But should wear it more often.
I've been elevated. I don't want to have any student class.
Great.
Push. Number 10.
টাইম ঠিক সেখানে তো আবার 10 থেকে হবে আমি ওকে সকালে কত নম্বর বলো কত নম্বর বলো 121 122 এমনি টাকা হবে না ওগুলো টাইম না দিলে টাকা অর্ডার হবে অর্ডার সে ফাইল এমনি দেখা হয় না আজকে তো অর্ডার সে ফাইল টাইম দেবে
কত বললেন
10
না না 10 না
আইটেম 10
না না আমরা 117 ও আচ্ছা
ওগুলো টাইম ফিক্স ম্যাটার ছিল 2 p.m. ফিক্স ছিল ওগুলো Item 11.
Lordship, I appeared in item 11 and 12.
11
Lordship, I'm led by Mr. Shamunto. He's a little unwell. We had to leave from court. Therefore, I'm just seeking an adjournment for today. 11 and 12, both, Lordship.
Not today, yes.
I'm grateful.
13 and 14. Item 15. 16. 17. 18. 19. 20. 21 and 22. আপনি in person করছেন
দুটো কেস 38 and 39. I joined Kolani Government Engineering College in 1996. It's Government College of Engineering and Ceramic Technology. Present. Please check WPST 39, Annexure 28. This confirmation letter. Page 28 of WPST 39. Secondary petition. First petition or secondary? There are two petitions, 38 and 39, WST 38 and WST 39. WST 38 is regulation for absence period and 39 is for past benefit. Which WST 39.
39, which page?
28 annexure.
28.
28. And first approval letter is annexure page 120.
Sir, we are asking you, where is your appointment in the Government College of Engineering and Ceramic Technology?
Yes, I retired from Government College of Engineering and Ceramic Technology.
Where is your appointment order appointing you in the Government College of Ceramic and Engineering and Ceramic Technology?
Page number 128.
Yes, show that.
WST 39.
Yes.
My problem is with my previous service at Kolani Government Engineering College. What I applied through proper channel to the post of lecturer with this pageant service. It's a page number 27 of WST 39.
Yes. So under your grievance is that you are working in this Kalyani college. After that, you were appointed in the ceramic college. You want that the period of service in Kalyani should be counted here as past service. It should be taken into consideration for all benefits. Also, there is about 550 days which you have gone without leave for pursuing a study that should be regularized. These are the two grievances. The regularization was rejected.
It's rejected by the.
By which order? Show us. There are two orders. One order rejecting your regularization, one order rejecting the counting of service. Where are these two orders?
Two others.
Where are they?
OA 27 of 2022, it's page number 72 to page number 72 to 79. WST 38. Order is 27 to 29. That was my application. 27 to 29. WST 38.
Where your claim was considered by the authority under order of the tribunal. Where is that order passed by the authority rejecting your claim?
27 to 20. 24 to 26. Order passed by Director of Technical Education.
There is the other one. There are two orders. Oh, so in one case there will be one order. The other case together.
Page 24. In the other case, 24. Yes, it's 24.
Yes, 20.
Yes.
During my absence period, I have been told to join by letter dated 21st December. You check Annexa page 18 of WPST 39, where I had been told to join, and I had been told that my absence period will be regularized as per government rules, and that's why I joined.
So which rule authorizes you to have a regularization of 2 years of leave without pay, extraordinary leave? Under which provision?
There is a provision of WBSR 175
Yes.
by 2 by 3.
WBSR 175.
WBSR 175. One 75 by 2 by B by 3.
$175
by 2 by B by 3.
No, you are referring to provision for study leave.
No, I applied without pay leave for the MTech course. I did not apply for study leave because in the study leave, government
The
has to pay.
provision read 175 to B3. What is it? Read
24 months for 24 months leave
for
the purpose of study.
But you never applied for study leave. How you can be granted a study leave?
No, my application.
You applied for extraordinary leave without pay.
Check Annexa page 15.
Page?
My application. Annexa page 15 of WBST 38. My subject was permission for leave for the study of MTech course.
আপনি কত নম্বর পেজ রেফার করছেন?
15, annexure page.
15.
15, annexure page 15 of WST 38. There is also provision of leave up to 5 years under Rule 34/1. And I rendered 29 years service in the same Directorate of Technical Education. And also, I would undertake theory and practical classes there for the BTech students. So upgradation of my qualification to the MTech level was useful for the students. So absence period.
So you are relying on this 175
by
B3
by 3.
and which other provision?
34(1). In original WSR book, that is page number 26. But it is another book. 34/1.
Very good. That's all. Anything else?
I will undertake theory and practical classes. Please check page number 21.
That is not material. What you have done is not material. The point is, can you just walk out of your employment and say that I'm going and you regularize this period? That is the point. What you have done is immaterial. Whether you have gained a educational qualification, you have increased or enhanced your educational qualification, that's not relevant. The thing is whether one day you can say I am going and then come back and say regularize the period.
College told me to join by letter.
We don't.
So I joined.
Where is that letter?
Please check annexure page 19 of WST 38.
Which?
Page 19.
19.
Yes. WST 38.
No, this is of 2004. You left in 2002. Did you have any permission before leaving? Is there any permission from any authority that yes, you please go? Do whatever you want.
I submitted prior application 6 months earlier.
You may have submitted 20 applications. We are not asking that. If they have not allowed you to go, can you just walk out?
During that time, my HOD told that it will take time because
We are not on that, sir. You are serving the government. You are guided by rules, regulation. Anybody one day can get up and say, I am going. Now I'll come back, you regularize it. Under which provision you can walk out without a prior sanction of leave?
Previously, I joined to the post of technical assistant.
Wherever you may join, that is not relevant. That is not.
DN was sanctioned 4 months later with the expectation of post facto.
That is not relevant. Those are not issues here. Only issue is whether you could have walked out like this for 500 days without any leave. That's the only issue. There is nothing else.
My another 2 points. After completion of my MTech course, I joined Colony Government Engineering College in 3rd January 2005. And
3rd January
2005.
Yes.
In that order, it is also mentioned. And I worked there up to 1st June 2006.
1.5 years.
Almost 17 years. And that period is beyond any dispute. But
17 years.
17 months. Sorry.
Yes.
From 3rd January 2005.
1.5 years. Yes. About 1.5 years.
Yes. But that period is beyond any dispute. But that service should have been added with my page.
Where it should have been added? It should have been added in your ceramic institute.
Yes, yes.
Under which provision?
Because I submitted application through proper channel.
Therefore,
lecture.
therefore, where is that provision which says that once you have submitted application through proper channel, you have to be given the benefit of that service? Where is it? Under which law? Where is the provision?
I applied through proper channel.
Now you are saying the same thing 3 times. You applied through proper channel, you worked 1.5 years. After coming back from study leave, you applied through proper channel, you were selected at the Ceramic Institute, you joined at the Ceramic Institute. Because you applied through proper channel, they should have granted you at least 1.5 years service. Under which provision?
Knowledge that, okay, then I'll sweat in, please give a, please give a date.
Why we should give a date? This is your entire case. 2 times you have gone to you have gone to the tribunal twice. This is not the first day that this issue is coming.
It is my knowledge that whenever I will apply through proper channel.
Based on your knowledge, the government will work. Or the government will work as per the rule.
And also I worked at Kolani 10 years, almost 10 years.
How is that relevant?
And so if 1.5 years, 48 days is deleted, then what?
Before joining the Ceramic Institute, were you relieved by your earlier employer? Before joining the Ceramic Institute, were you relieved by Kalyani? Is there any order releasing you or relieving you from Kalyani?
I had been told to join within 15 days in the appointment letter. So
were you relieved? Were you relieved by Kalyani? We are asking.
Later on.
Were you relieved by Kalyani? Is there any order saying that yes, you are free to go?
My higher authority director of technical education told to join within 15 days after getting the letter.
Did you get a relieving from your Kalyani Institute?
I informed them and then.
So everything after information. I informed, then I went on leave. I informed, then I joined the other post.
They told me to join by letter, otherwise I would not join there.
They did not proceed against you. For departmental proceeding was not conducted. You are appearing.
In item 21, I'm appearing.
There is no proceeding against him.
It doesn't appear because of the only thing that I've gone through this order in. So according to, so far my knowledge goes for an order should sustain. There is
Order
no such
should sustain. We are surprised
because I just now I've been briefed. I couldn't able to go through the other documents also, and no instructions on it has yet come to me. So
it's as if he will do whatever he wants. Whenever he wants, he will go on leave. Whenever he wants, he will leave the employment. And as per his understanding, it should all be regularized. Sorry.
There is nothing. My liberty to leave the job, but government told me to join by letter. That's why I joined. Now it is a breach of.
And if you didn't join, what would have happened? If you did not join, what would have happened?
Nothing was happened. I would join private college or another, but so many years later, government cannot oppose it.
Proceedings, show cause notice and subsequent disciplinary proceedings should have been initiated.
So then they should have taken charge against me during that time. Now so many years later, what shall I do?
No, that is, they have not done, so they have not done. We are not on that. We just wanted to know whether they have done it. They have not done it. But that you cannot claim anything. There is no basis for this claim. Nothing.
And I was
Where is the tribunal's order? Let's see.
548 days. But I served there 10 years at Kolani Government College from 1996 to 2006. And for my MTech course, I am already getting 2 increments. Kindly check page number 95, where it is written that I am already getting 2 increments for my MTech course. And same GPF has also been continued.
Is there any relation between the two organizations, Kalyani and Ceramic Institute?
Kalyani is it's a government engineering college. Ceramic is also government.
That's all.
And under same directorate.
যাদবপুর তো এটা সেরামিকটা তো যাদবপুর
না এটা বেলেঘাটা
বেলেঘাটা
only I am facing problem. There are so many employees have done MTech as well as they have got salary and they have worked there. And I have given, and I have example also.
Both the orders passed by the authority, there is nothing different other than the letter number. Where is the tribunal's order pursuant to which these two recent orders were passed?
অর্ডারটা কবে কত পেজ ডিসিশন অর্ডারটা কত পেজ দেখুন
Certain or
ডিসিশন অর্ডার না না স্যাটেল না ডিসিশন অর্ডার যেটা অথরিটি 38
The other case. 0826.
It's 26.
In 0826. Where is the order passed in 0826? In WPST 38, can you show us?
ঠিক আছে কি কোশ্চেন
Page 28.
উইথ ফার্স্ট ওয়ে অর্ডারটা চাইছে কোর্ট দেখতে চাইছে পেপার করুন
Both orders are of the same type. 21-9. Same thing. We have seen his application. That is good. This is the application. Well, what he has claimed here is permission for study. See, now I'm requesting you to give prior permission for study so that I can get preparation for the admission to and I shall be obliged if my absence is ignorance. Yes.
But only only the point is involved. But in absence of any one of the specific provisions in the rule, his prayer for regulation was rejected. So, as it appears from the order in place. I do not find any other points to make submission right now.
Please just see one thing. Third page of the tribunal's order. Last paragraph. Read it to the next page. He may land in trouble because of this. This observation, whether the tribunal should have made such observation.
State it is not a matter of few days, but it totals 48 days. As a government employee, it is surprising that he not only disregarded the rule and without formal approval proceeded to pursue his MTech degree. But despite show-cause notices, he was stubborn and did not bother to join his duty. Government employee disregarding the formal approval and disobeying the directions, the show-cause, and absenting himself for a long period of 48 days is unparalleled and classic case of
Yes.
right in some cases. Therefore, thereafter.
Now what can be done after 20 years? So that to the tribunal
Proceedings at this stage
cannot be. It's a stale charge even if it is. So there is no point in making such observation. It will only cause him harassment. So that extent.
But this is not a case of harassment since the authority, so far my knowledge goes, so far the authority found there is no such rules. Therefore, his prayer was rejected.
No, there is no such rule. We have
Observation of the tribunal. Observation. The authority did not act it upon on the basis of this observation.
No, but this threat will be looming over him.
Give an example of rule, annexure page 22. Already, annexure page 22, WPST.
WPST?
38, annexure page 22 and 23.
22 and 23. What is
example of sanction of it?
It is referring to another document which is not relevant here. Because,
no, this is he's saying others have been.
Taking an example.
That case is not before us.
Not relevant here.
In my college and also at Kolkata Community College, so many faculties did MTech while they were in service.
But
they did not face any problem. Please.
No, I'm not saying.
Kolkata Community College. Study from 2001 to 2007 and MTech 2007. No problem. So many faculties in our college also. They are taking salary and they are doing MTech. Being honest, I did not take any salary. This is my problem.
That's what I'm saying. But he was on leave. It says he was on leave.
Based on this, the government, as per last page, page 3, last paragraph, as my lord referred, based on these observations, the authority as on date did not take any steps. So that you can say that was mere observations. Good luck, rather, we should say that.
At Kolkata Community College for 10 years. And I was absent only for 1.5 years. Charge should have been taken during that in 2002.
He was on leave.
Yes.
Nothing can be done, sir.
And can I give example of other faculty of Kolkata Government College while he was in service, he got salary, and during that time he also did MTech.
We don't know.
Of the same college.
They are not before us.
Yes, right.
They are not before us. We will not look into anything which is not, the person is not here, we will not. Yes, take down. Heard the learned, he heard the